Thank you. Good evening. I'll call to order this Tuesday, June 2nd meeting of the Zoning Commission. Actually, I'll just note Commissioner Randolph is out and Commissioner Churchill will put in his place. We only have one item to vote on this evening, and that is our meeting minutes from May 26th. I have a motion on that item, please. Commissioner Capozzi.
Motion to approve the minutes.
Thank you. Commissioner Capozzi moves to approve. Do I have a second? Commissioner Churchill seconds. Thank you. Commissioner Capozzi, comments?
No comments.
Churchill?
No comments.
Any other comments or questions? All those in favor of the motion to approve the May 26th minutes, please raise your hand. Thank you. Motion passes unanimously. And then we'll move to our public hearings. First is on section 4.12. Beach District provides clarification for the allowance of sand, fences, post and rope, and deer fence property delineations permitted above the coastal jurisdiction line. We're just going to you.
If you'd like.
Commissioner Levy.
Yeah, I'll try and keep it brief. We've got a lot to do tonight. This issue about fences, this came about when we amended section 19.2.1, which dealt with fences on corners and so forth. And that specifically provided, except as provided in 4.12, which deals with the setbacks in the beach area, and specifically provides that the setbacks apply to fences. And as it stands right now, and under that regulation, technically, no fences are permitted between the back of the residences, basically on Fairfield Beach Road and the water, which clearly is not the situation. Now, initially, I looked at it, well, maybe we need to decide fences, but then as I thought about it further, we didn't need to get into an epistemological debate as to what is a fence. Rather, the need is to amend 4.12 to properly reflect what the commission and our zoning enforcement officers recommends as appropriate fencing permitted between the houses and the shore. Well, some people might prefer total access to the shore and so forth, and keeping it open. I might be one of them. That clearly is not the sentiment of most of the residences and many of the Fairfield Beach residences, let alone there are property rights to be addressed. So the question is, how to, what to provide for. And I have spoken since to zoning enforcement officer Decker, who, along with Mr. Wendt, has previously taken the position, and it's a very commonsensical one, that in interpreting 4.12, that the intent was to avoid 6-foot stockade fences and the like, to obstruct people's view of the shore. And he, in the past, has taken the position that the setback restrictions were not intended to apply to sand fences or post and rope barriers or anything of the like. The only trouble is, if hopefully a long time from now, if the new zoning enforcement officer that might view it differently, or if one neighbor decides to sue their other, a regulation currently provides, it says, no fences are permitted. So I think the commonsensical approach is to amend 4.12. And I've just put, so basically people will know what is permitted. And, I put in a draft for discussion with some thoughts, since discussing it with Mr. Decker. And the key things are that this will apply landward of the coastal jurisdiction line, which is different than the average high, median high water line. It's actually further landward. And in Connecticut, in Fairfield, I think it's set at 5.2 inches elevation. And it needs to be there because if you look at the, Coastal Jurisdiction Act, it provides in 22A-109B, specifically mentions fences within the coastal jurisdiction area as being subject either to its or our review. So I think we do have to limit it to areas landward of the coastal jurisdiction line. Otherwise, people would theoretically could have to apply for permits. Not likely that's going to happen. And so, to my mind, and this is what we need to decide, limiting it landward to coastal jurisdiction, which for some people, it might often is the rack line. I had in there that it should be not higher than 3 feet. According to Mr. Decker, 2.5 feet is the appropriate level. That's more consistent with the height of most sand fences. Whether or not it should be limited for purposes of erosion control, or whether sand fences should also be allowed as barrier fences, that's something for the commission to decide. And I'd just be looking for a sense of the commission on that. Post and rope boundaries, again, limit that to 2.5 feet. And again, it's to keep it minimalist. You've got your posts, only one rope going across. And Mr. Decker felt that we should not allow for deer fencing because he did not think that would be appropriate down there. So probably forget number 3. Number 4, such structures as are already permitted. Those would be things already permitted by deed. And then whether or not you want to, we probably should put in there are some areas where there are decks between the houses and the shore. And those would fall within structures less than 1 foot. But that might be subject to coastal site plan review. So those are my thoughts. So really, if the commission is inclined to amend 4.12, it would be to limit it to landward of the coastal jurisdiction, keep the height at 2.5, limit it to sand fences either for erosion control or for any purpose, post and rope 2.5 feet, forget about deer fences, and if so inclined, structures less than 1 foot, which would allow for decks. That's it for me.
Thank you. Commissioner Levy, questions? Commissioner Braun?
Oops. This is a question for Commissioner Levy. So I'm looking at the actual regulations that are posted on the town website. The section that's not changing is the first paragraph down to where it says this setback shall also apply, right? That whole first paragraph is exactly the entire section we have in our regulations right now. I just want to clarify what we're changing and what we're not changing.
I believe that's the case, but
Okay, so
lest I misspeak, let me just take a quick look.
I just kind of proofed it. It looks like it's, well, actually, this setback shall also have fences and structures more than 1 foot above the ground. So what you did is you took the last sentence out and you exploded it into what you have below. So the last sentence of what's in the regulation is not in your first paragraph. That last section of the current regulations 4.12 says, this setback shall also apply to fences and other structures more than 1 foot above the ground. So you're taking that section and you're adding detail to that to allow certain fences, but not others. You're sort of liberalizing it, if you will, in a way. Is that how you see what your changes are?
As it stands right now, it says it applies to fences and other structures, which would mean they're prohibited. What I'm saying instead is this setback shall apply to fences provided the following shall be allowed. So basically affirmatively telling people what they can do.
Okay, so that's great. So you're
it up to discretion of zoning enforcement or neighbors.
And a month or so ago, we were talking about this, and there was a different definition. And does that compare to what you're doing here? That was sort of a definition of what a fence is.
Yeah, if we define what we mean, we don't need to define fence.
So this is taking that definition and replacing it with something much more detailed, just so I know exactly what we're doing.
I'm just forgetting about defining fence and simply stating what is permitted in the setback area above the coastal jurisdiction line.
Okay, and then one little clarification, number 1, sand fences landward of the coastal jurisdiction line. I always thought that was the mean high water as opposed to high tide line. I think there's a difference in the two. Maybe Mr. Mullen can explain that, but I believe which is the more technical.
The coastal jurisdiction line is different and it's generally higher than the mean. The mean is the average high tide, which means that for half the month, if you actually went to the mean high tide, your fence would be underwater, and people who ventured past it at low tide would either have to swim or trespass to get back. The coastal jurisdiction line is set by deep, and they Since 2012, they simply defined it at an elevation of 5'2" rather than trying to figure out where the rack line is.
But is the coastal jurisdiction line the same as the high tide line or the mean high water line?
We don't use high tide line anymore, but it's closer to the high tide line, the highest high tide line rather than the mean, which is the average.
So you're moving it up toward the homes?
Up towards the home, which is consistent with the statutes, specifically 22A 109B, which gives deep jurisdiction over fences, anything between the coastal jurisdiction area. So south of that. So basically
So-
doing
yeah.
compliance with the statute, unless we pass other regulations authorizing us to then review every fence in the area. Basically, it should be there. And as a practical matter, I think most of the fences, I don't think anybody is going to their property boundary at the mean high tide line, because otherwise people would be walking over it half the time because in high tide, it's underwater. So
I just think that if we're going to use a definition, it has to be the definition that's used uniformly. So I've heard three versions. I've heard high tide, and mean high water. Whatever goes in there, it should be whatever coastal jurisdiction is defined as, don't you think?
I'll defer to Ms. Harrigan, but I think coastal jurisdiction line is the one that DEEP recognizes.
It's defined right now with, as elevation 5.2. So at least it's a clear delineated contour line.
And that also is the jurisdictional line for many issues for DEEP. So it keeps
And
us.
that-
Right. And I think inadvertently for property owners, none of them would actively want to have to get a permit from the state.
Mhm.
So I think providing this level of guidance for them allows them to stay solely within Fairfield's jurisdiction instead of then having to enter into obtaining a permit from the state for something as simple as the property boundary barrier that that Commissioner Levy has defined for us. Which
Agreed. Didn't want to have the definition in there if it is not the correct exact definition of what coastal jurisdiction line is.
And I would just leave it because sometimes that gets revised by the state. And, I think much like we've made reference to other state statute references within our regulations, I think it's fine to say it needs to be above CJL. That's very easy to find on DEP's website. If they should go back and change it with sea level rise occurring and say it goes up to elevation 5.7, we at that point would not have to go back to revise our regulations, but it would revise as CJL revises.
I think we're all saying the same thing. My only point was maybe we should cross out the part in parentheses that says high tide. Because to me, that's putting a definition that doesn't need to be there probably, and it could be misleading.
It's more explanatory than intentionally part of the
Yeah.
language.
Okay, that's just my one thought. And then about the other thing about the height and the number of ropes, I'm not familiar with what's actually used on the beach. Is that how people usually demarcate their property, with a single rope? It says post and rope can only be 3 feet high, obviously down to the coastal jurisdiction line, wherever that is. Right now it's 5.2. That could change. So that's why the phrase coastal jurisdiction line should be the one used. But so the post can only be 3 feet, only one horizontal rope between posts. The lowest point of the arc of the rope shall not exceed 6 inches from the ground. Is that the typical way it's done now, or would that create sort of a burden on people based on what the practice is right now?
No, that's typically the way it's done.
Based on my observation, that's what I've seen there.
Commissioner
And then
Monahan.
Yeah, deer fence, why are we keep taking out deer fence, other than I do respect Matt Decker as being knowledgeable about this. Is there another reason why are we taking out deer fences?
Just didn't think it was appropriate down there and didn't think it would stand up. So
Okay. And deer fences are very tall, aren't they very tall? Like,
it would still be limited in height in 3 feet, but they're
oh,
like a
okay.
sand fence,
It's much thinner material.
or a good high tide and they'd
Yeah.
be washing out the shore. So
Okay, I hear you. Thank you.
Commissioner Monahan.
What's the goal of going from 3 feet to 2.5 feet? And can you specifically again cite exactly what the changes are to the existing 9.9 town regulations by line versus what notes on your page?
I'll show you the difference. I brought a tape measure.
Great. And how
Uh,
many, and what percentage of the posts currently at the beach are accessible?
I don't think, I'm just going by my memory, but this is 3 feet, and that's certainly higher, I think, than what I've seen out there. And Mr. Decker indicated that 2.5 feet. Which is about here, is the height of an average sand fence in the posts.
So is a half a foot that big a difference? And why was it originally set at 3 feet? And we have adopted it at 3
I
feet.
picked the number out of the air and then I spoke to him and he suggested 2.5.
But if it's currently 3 feet.
It's not,
It's not-
that's all, this is
Oh,
all.
So it
draft.
says, so when I read Town of Fairfield zoning regulations effective 9/9/25, and I read a page, you're saying this is not
All the
accurate?
stuff below shall be, all the stuff allowed.
So then why does it have at the top of the page, Town of Fairfield zoning regulations effective 9/9/25?
It's a draft that I cut and pasted as an example.
Okay, so this should be,
This is not passed. This is just a draft.
this should be marked as such.
Fine. I didn't think there was any confusion. So
There's confusion because someone logging in and logging into the background materials and is reading this, it looks as though this is the current regulation. We don't have the backup documents. It says Town of Fairfield zoning regulations effective 9/9/25, but this is not. This is a draft of what you're proposing. But
The record should
also,
so
there are no
reflect.
red lines here in terms of what you're changing and what you're adding. It's just a draft, newly written, marked effective 9/9/25 with new heights. And I don't disagree that it's great to qualify so that people know exactly what they are permitted and not permitted to have down there. But this is completely and utterly misleading, the way it was let out, listed out. So I would appreciate if this was updated with a red line, also highlighted, bolded, so that the general public can realize what the new changes are versus what the current regulation is. Because this to me is not accurate, and that anyone attending, anyone listening, anyone who lives at the beach area knows exactly what it is that this commission is looking to adopt. And therefore their voices can't be heard for or against if they don't know what they're reading.
it is on for a public hearing.
Yes, exactly. But if you.
Okay,
So noted.
The point is- the point
9/9
is made, we can continue on.
And in terms of any changes, it's the original up to the words setback shall also apply to fences and other structures. And then starting with provided, however, the balance of that is all new and subject to review. And you'll note within it, it even says following subject to commission discussion and approval. So it's clearly not the final regulation, but so noted. I mean, I think it might be helpful to just get a sense without voting so that we can redraft this either by me or staff as to whether people agree with a 2.5 foot.
Seeing Commissioner Braun has thought.
Or getting
Commissioner
rid of deer fence and allowing for structures like decks less than 1 foot.
Commissioner Braun.
Yeah, I just, I think that would be helpful for next time. We're obviously not voting on this tonight anyway, but there is one other slight difference between what's on the current zoning regs and what is being proposed. Where it says, the very last line in the zoning reg right now, 4.12 says this setback shall also apply to all fences and other structures more than 1 foot above the ground. So that is language, is that coming out? Because that's not on this page at all. And then the new portion that should be redlined would be provided, however, that the following shall be allowed. And then we go into all your proposed changes for discussion. But the over 1 foot above the ground, what is the significance of taking that out? Or what is?
And as I said
Homeowners.
early.
Yeah.
I was suggesting we add back in, provided the following should be allowed. And then beyond that, that would be like number 3 or 4, structures less than 1 foot, subject to coastal site plan review, which allows for existing decks, which are seaward of the setback lines. So basically, take it out above and put it below into the provided, however.
Deck is under 1,
1 foot above ground.
over 1 foot above. So what is under 1 foot? What
It's
types of
basi-
structures are under 1 foot above ground?
Basically a deck that's on ground level. We don't
Okay.
want massive decks 5 feet high.
So that restriction, so everything that follows that you're defining should be things that are greater than 1 foot above the ground, right?
And through you, Mr. Chair, if I could just qualify that the beach district regulations don't exist without the floodplain regulations also. So there may be some circumstances where you might be able to do the 1 foot above grade where there was a pre-existing deck, and you might be able to replace it in part, in kind, if it's not in a velocity zone. If it's in a velocity zone today, and it's more than a 50% substantial improvement, you may not be able to replace those things. So let me just caveat some of what's within the beach district regulations that has historically been in the beach district regulations, as when you have new construction, those floodplain requirements will now take effect. So, you know, I think some of what you're asking, Commissioner Braun, may be able to be reinstituted in if, like, for example, you have a pre-existing, was approved by the DEP, concrete patio that is waterward of the structure, and you have that DEP permitted, you might be able to replace that. In most circumstances, you're not going to be able in the velocity zone to do a grade level deck. So if this is a Long Island Sound adjacent property, we're going to look to what those flood protection standards require of us first. But this is language that's been for that below 1 foot component. That's language that's always been in the regs.
So I think that should be restored. And obviously you have to, if you want to do anything, you have to follow all portions of our regulations, and they might intersect or overlap, but there's nothing wrong with restoring that over 1 foot above ground provision that was in the original one.
Actually, less than 1 foot.
I'm sorry.
Yeah.
No,
Yeah.
over more than 1 foot above ground. The setback applies only to things above 1 foot above the ground. Under 1 foot above the ground, the setback does not apply to.
Well, it's allowed, still within the setback, less than 1 foot.
But it's going
So
to
I
be
would
like,
think that should be restored. And then I had another question about, I don't want to monopolize, but I do have a question about DEP. What are the DEP allowed structures that would be allowed? In item 4, you say structures or fences or encroachments as allowed under a permit issued by DEP in accordance with 22A-360. Is that what Ms. Harrigan was just mentioning, or other types of things?
it's very limited. You know, the DEP waterward the face of the house, we really don't allow too many structures, but if you've got something that faces Pine Creek, for example, a lot of property owners have been able to put in docks, you know, ramps down to, you know, small boat docks, especially if they're on Pine Creek. So that would still apply. On the beach side, it's really limited because it is such a high velocity area, and they don't really want the displacement of natural sand. So, you know, it's going to be very limited as to what we'd be able to get permitted beyond that.
Thank you.
Any final comments on what's proposed?
I'll just summarize it. Either me or staff, my sense is that I'll submit something in final form, 2.5 feet. I'll leave it that it's not restricted simply to erosion for sand fences, but they might be permitted, for instance, to, you know, keep dogs and children in, or to demarcate property lines, and get rid of the deer fences and reinstall the less than 1 foot fence, and I'll have it ready for a future agenda.
Commissioner Capozzi?
I want to just make sure, the 2.5 feet, I know, Matt, that was his suggestion, but I just wouldn't want, like, to, Commissioner Monahan's point, I wouldn't want, like, if you know, I would rather err on the side of having it be a little taller than having a bunch of people suddenly have to buy new fences down at the beach because they're, you know, 3 inches too tall.
I'm not too concerned that Mr. Decker is going to start issuing citations for 6 inches. So, but I'll take a look at what's there.
Okay, sounds good.
Commissioner Monahan?
6 inches may not seem like a big deal, or is it if you really feel the need to reduce the number by a half a foot? if it's that important to you, maybe we can just keep the 3 feet, which is then the existing, just in case.
This doesn't exist. This doesn't
Doesn't
exist.
exist
That's
at
the
all.
opposite.
That is all
Oh,
new.
that's why when I'm reading this
Right
town
now,
of
they're
Fairfield
not
zoning
allowed.
act regulations, yes, it's really not the current zoning regulations.
Correct. Yeah.
Just
Permitting
like
it.
other people who might have read it that way.
Yeah, so Steve suggested 3 feet and then Matt said, no, it's 2.5 feet. So that's why we're
Well, I
talking.
need to go down and measure, so I'm gonna go down and measure, and the question is, where do you measure from, right? Because the sand is always moving.
Get back to defining fences.
All right, any final questions, comments? All right, thank you. Is there anyone here who wishes to speak on this item? Any member of the public joining remotely who wishes to speak on this item?
I'm just putting them together now.
If you are joining remotely and wish to speak on this or any other item this evening, please remember to sign in and chat and indicate that you'd like to speak.
Steve,
have a
for
que- is
drafting
it-
that, by the way.
Is it just for this one item?
For now, just on this item. Ellen?
No, we do not have anyone, Mr. Chairman.
Okay, thank you. Okay, so we will close the public hearing on this item. Move on to our next, section 25.13.4, conservation and parking management districts. Proposed language that retains minimum parking standards for residential developments less than 16 units for 2 areas not to exceed 8% of Fairfield's land area as permitted under Public Act 25-1. Areas under consideration include portions of Southport and portions of the Fairfield Center, extending northerly to the west of Fairfield University and south into the residential B duplex zone along Reef Road. I know Commissioner Braun, I believe, is going to present, but Commissioner Braun, were you looking for Ms. Harrigan to address those questions you had sent in this afternoon?
Yeah, just to explain a little bit, this has come up a few times, and I don't know how many people are there, but I think the public should also be aware of why Commissioner Monahan and I, why we've been pushing this, because on July 1st, 2 provisions of the housing law that was passed in November go into effect, and that's my biggest concern. I don't want to imply it's a deadline beyond which we can't do what we want to do, but it is kind of a deadline because if the day goes by and we don't have regulations in place to preserve parking, then on that date, somebody could file an application and provide no parking or not enough parking for an up to 15 unit apartment. And also the same day, commercial to residential, but in our case, it would be mixed use. Conversions could also take place as of right without a public hearing through a summary review, which is very fast and we have no discretion. And so those 2 things going into effect on July 1st, combined with our zoning regulations that we passed recently, allowing taller buildings and more residential, create a situation where we have the ability to control all of that to some extent by putting these parking zones in that the law does allow us. It allows us to pick 2 zones of up to 4% each of the entire town's area. And there's a lot of math and calculations that go in. And honestly, the law does not define it very well. It does not say what you have to do. I don't know that I've ever heard of anyone having to create, any town having to create a zone where you are limited in how big you can create it. So that makes it interesting. Because, can you carve things out? Can you have holes in it that are not included? Do you include internal roads and things like that? So there's many things that could come into play. And also, how big is the town? I've seen 2 or 3 different numbers. But so we came up with one, but I'm very interested to hear, I think Mr. Barnhart is here. I'm interested to hear what he says about parking in general around town and studies we might be doing. But my issue again is the time frame, and that's what I was hoping Ms. Harrigan could tell us about, because we have an appeal period of 15 days that I believe that means if we adopt a resolution or a change in our regs, or a map change is a change in our regs, then it really can't go into effect until the 15th day. So I calculate that as being June 16th, and I know we have 2 other Tuesdays. We have the 9th and the 16th, although the 16th is usually our day off. It's the third Tuesday of the month. So those are the questions I posed about time frame. I'm not trying to push anything to be voted on tonight, but I do think we want it to be voted on or adopted, whatever we're doing, enough time so that the appeal period ends, right before July 1st. So that was my question. And that was my sort of sense of urgency.
If, Mr. Chair, if I could
Sorry.
clarify. So I think you had asked a couple questions in the email, one of which is, we are proposing a regulation amendment to section 25.14 of the parking regulations, which enacts, the parking standard that matches the map that the commission will need to discuss for the Conservation Parking Management District that you choose to approve. I think that's covered by the notice that we've already completed. I think if you make revisions to the map that you want to include, that's also covered by the notice that we've completed. It's really going to be up to the commission how you proceed collectively together through your discussion. In terms of the time frame, I want to be clear to the commission that we already adopted parking regulation changes that allow for residential developments with less than 16 units to not have any parking standards. That includes our residential districts, it includes our commercial districts, and we've not had a run on applications for this. I want to remind the commission this past year, we saw 12 830G applications. As you know, 830G applications can waive all of the town's standards, including parking. And none of them provided an application proposal without any parking spaces. So, the July 1st deadline is for the regulation changes. It doesn't apply to the conservation parking management districts, which can be adopted at a later date. As to the conversion of commercial to residential, we did also adopt those at the end of March. So those are already in effect in our regulations, but properties have to meet a standard in order to do that conversion from commercial to residential. They either have to be 100% vacant or they have to be more than 50% vacant for a period of at least 12 months. Again, we've had no applications that represent a project that meets that criteria since the time that those regulations have been in effect. So there's no July 1st deadline where the option to adopt these goes away for the town. We already have these regulations in place. I think that the commission should take as much time as they feel they need to feel comfortable with the districts that you decide to adopt. And we've had a lot of public input related to that. So I think you should consider and be thorough in your review of these and your discussion of these. And, know that again, 830G is the true indicator of waiving all the town's regulations. And all 830G applications, past and present, have all supplied parking. So I just want to, have the commission understand that market forces still dictate for that an apartment building in Fairfield, you're going to supply parking.
Just add one thing.
Can I clarify a couple points?
Commissioner
on that?
Monahan.
Okay, sure.
Note, 131 Beach Road is a recently completed building. There is one parking spot per unit, 1 or 2 bedroom units, and you can buy an additional spot. There aren't that many additional spots, and everything else is off street. And there are problems and challenges with that development, which is downtown, with using on-street parking. Not sure if you're aware of that, but that is absolutely the case today. So I just want to go on the record by saying that there are on-street parking issues that arise from these denser developments.
Commissioner Braun.
Okay, just to clarify further, because I do think it's important we understand these sort of foundational, the sort of the legal framework that we're working in. So I agree, 830G, they don't have to follow any regs, including parking regs or anything else. And they do provide parking, but there's overflow parking. And, as Commissioner Monahan has pointed out, that there's probably not enough because I know that they're parking in other places. And so there's a concern that even if people do, developers do provide the limited amount that some of these 830G does. If you start expanding multifamily over commercial throughout the downtown area up to 3 stories above commercial, that could have a very bad cumulative effect. And the law supersedes our regulations. So yes, we did pass off-street parking and loading regulations recently. And we do require parking for up to 16 units in our new regulations, right?
Not,
Yeah, we do.
because we
In
cannot
our
based on the
regulations, we do.
statute. No, we do not, because we're not allowed to per the state law.
Well, I'm looking right here. It says properties with dwelling units up to 16 units recommended as follows: single family residence,
Recommend.
2 spaces, accessory dwelling unit, 1 space, multifamily, 1
requirement.
space. Pardon me?
Because we can't require it per the state law. So we have a recommended ratio.
Right.
But that's not a requirement. So if they say, that's nice, you recommend that, we're only going to provide 1 space per unit, we legally, the statute doesn't allow us to enforce our recommended ratios.
Starting on July 1st. So that gets to me
Oh, no.
to the whole point, right?
We already adopted those regulations.
Right. We adopted those regulations saying that that's what we want. And on July 1st, we can't require any parking for up to 16 unless we preserve it in one of these parking zones. Is that correct? Is that a correct statement?
In place already. The July 1st is the date by which we have to be in compliance. We complied with the regulations we already adopted.
It's not accurate.
It is
We don't
accurate.
have to do anything by July 1st. All we have to do is
Nope.
try to preserve what.
We have to comply with the state law by July 1st. The regulations that we adopted comply with state law. They are already in effect.
So I think we're all saying the same thing. I think what we're all saying is on July 1st, there's a state law going into effect which says, except in up to 8% of the town, we are not allowed to require parking for up to 15 units of multifamily anywhere in town. Is that a correct statement?
Yes, that's what the state law
Okay.
says.
Right. So that
It doesn't
supersedes
change
any
anything.
regulations we have.
It does not
So-
change anything about our regulations, though, Commissioner.
Well, it almost is a moot point now. There's only 2 weeks left, but starting on July 1st, there will be no ability for us to require parking for up to 15 units. And by the way, that's going up to 16 units in September, according to what the legislature, they expanded that to 16 units. So,
We adopted it at 16 units
Right.
and below.
Right.
So we adopted it understanding that they were going to correct the 16 donut hole in the statute. So that's the language that we went with.
exactly.
And again, this applies to any residential development with up to 16 units. As
Correct.
stated, when we looked at the parking regulations themselves back in March, I don't think that custom home builders are going to start to build residential buildings without parking associated with it. So,
Again,
I think
correct.
there's a practical reality to developers and what they're proposing and what we've seen for projects that have come before the town. And, for the demand in Fairfield, again, a host of 830G applications this past year. All of them included parking. So we don't have to adopt this by July 1st. I don't think we're going to be that far off from that, but to keep repeating the July 1st deadline when we've already adopted these standards and we haven't had a run on applications, it's providing false information to the public.
I don't think anything I said is false. I think I'm saying exactly what the law provides. The law says.
Misleading. It's wildly misleading to tell the public. No, let me just be clear. The commission, it's at the commission's discretion. So the commission at the next meeting, if that's the direction of the commission, can vote to adopt these. And the commission can take the position that because these regulations are in place, we should move quickly to do that. But that is separate. So to your point, if the commission feels that we should adopt these quickly because the regulations that are in place put us at risk of developments coming in with no parking, that's a position you can take. But the July 1st deadline has no bearing on us practically because we already complied with it in March.
And again, it might sound like semantics, but we didn't have to do anything. We just have to follow the law. The law says on July 1st, we cannot require parking for up to 15 units of residential anywhere in our town, unless we preserve up to 4% in 2 zones. So, but I think we all agree that that is what the law says. So reasonable people can disagree on whether there'll be a run on it or who will do what. And that's really the basis of what Commissioner Monahan and I are proposing, which is to preserve the entire small business area of the Post Road area and into Southport and part of the beach area as being a very, very high priority, because we don't want to have problems with our small businesses, with people being unable to patronize it. And this is founded on a lot of information and data, which we can present. But, again, there's room for reasonable people to disagree on exactly where those zones should be. We propose one zone. We need another zone too. We need both the zones. And I would really hate to be caught on July 1st with applications coming in, because the development community knows that the law allows not only our inability to require parking up to 15 residential, but it also allows not just for abandoned commercial, but for any commercial to mixed use redevelopment conversion as of right. That starts on July 1st as well. We tied our regulation into something that was passed last summer, but the new housing law, my understanding says any commercial, not just something that's already abandoned. So not like, say Bed Bath and Beyond or Rite Aid or something. It could be any commercial. It could be, where the pantry is, or it could be somewhere else that could be converted. Is that your understanding, Ms. Harrigan, that the new housing law does not confine it to abandoned commercial to be converted as of right?
No, I think that those criteria still exist. So it doesn't eliminate those criteria.
It has to be abandoned to do the conversion?
It has to either be 100% vacant or 50% vacant for at least a year.
As we go forward, I'm gonna look up the housing law, because that's not my understanding.
All that this past year added was it provided an incentive that we would be eligible for a gray field funding opportunity through the DECD. That's what this past 8002 added in conjunction with that public act that was approved, which was PA, I think 149, that references the conversion from commercial to residential.
So section 16, which is the one we've been talking about of the housing law, right? It says, it shall allow for as of right development, for development of a transit community middle housing development, which I believe is a 9-plex, right? Is that defined as a 9-plex?
Defined by the statute as a 2 to 9 unit residential project.
Okay, and that could be mixed use, right? That could be over commercial, right?
So what we did is, if you read the statute, it says the commission has to allow for transit middle housing.
Correct.
Is 2 to 9 units, or mixed use development. And we chose mixed use development. So
Correct.
within our commercial or mixed use districts, we prioritize having ground floor commercial with residential units up above. And we had to allow one of those alternatives by summary review. In review of these particular regulations, we selected mixed use. So there is going to be a requirement for the ground floor commercial, residential units up above, within the height, story limitations, setback limitations that the commission has in place and that the commission has recently revised. That's why we've been really focusing on the architectural standards, because that would also be part of the summary review, and ensuring that we get buildings that we find attractive that are within those envelopes that are permitted.
Agreed. So, but I don't see anything in here that says it has to be abandoned or vacant or anything like that. I think
that other section. So keep in mind that when you have a new act that gets adopted, it only replaces certain sections of the state statute. So those other sections of state statute exist that pertain to those qualifiers for conversion of commercial to residential.
I would really like to get the town attorney's written opinion on that, because I don't agree with that, and maybe I'm wrong. I hope I'm wrong, but the way I read it is, the new housing law says any commercial at any time can be converted to mixed use according to our regs. Okay, nineplex, so anybody can convert any commercial building starting July 1st to mixed use and put a nineplex above of the Pelicano restaurant or something like that. So that could happen on July 1st with summary review, meaning they would have to follow our regulations more like a checklist. We wouldn't have any discretion. It doesn't have to be abandoned. That's my reading of the housing law.
That's not correct. So John just looked up the public act for me. It's PA-164. That's still in effect. The only thing that 8002 added was the ability, if you allow for conversions by summary review, to provide access to that gray field funding opportunity through DECD. It didn't replace PA-164 in its entirety. Only a portion of that section.
Can we get the town attorney weigh on that? Because that's pretty important.
It's-
I like a legal
I think the
opinion on that.
majority of most of the commission, and feel free to jump in if
Yeah.
others agree,
Okay.
seem to be clear on what the law says here. That. So I mean, we're not going to seek a legal opinion every time a commissioner is unclear on a particular piece of the law when there's large agreement on what the law means here.
I think we need to know by our town attorney what the law calls for. We've got two seemingly conflicting parts of two different laws. One that went into effect last July, one that went into effect in November. And I think we need to know that.
So if I could through you, Mr. Chair, we adopted these regulations as part of our regulations when we updated our design business district regulations back at the end of March.
Mhm.
So these are already in effect, and the town attorney reviewed that language that was proposed. He already reviewed this language.
The state law supersedes it. And if this state law says you can convert anything, not just something abandoned on July 1st, that might be the state law. I'd like to know that.
Well, Commissioner Brown, hang on, could I just ask a question to you? Because I know this is, you have a proposal for a parking district. And I've heard a lot of folks suggesting that this commission is trying to delay discussion of this parking presentation. So if you would like to turn to the parking presentation, I'll give you an opportunity to do
I'll
that.
be glad to, but in the meantime, I'd like to make a motion that we get the town attorney's opinion on that exact issue.
What exact issue?
Commercial to residential.
Whether section 16 of Public Act 25-1, which used to be called HB 8002, allows for as of right conversion of any commercial into either mixed use or residential starting on July 1st, and does not require it to be abandoned pursuant to the prior law that went into effect a year earlier, 9 months earlier.
Commissioner Braun, I'd like to ask that Ms. Harrigan read the exact language in the statute into the record, so there's no question as to what it says.
So section 16 of House Bill 8002, on or after July 1st, 2026, any zoning regulations adopted or amended pursuant to section 8-2 as amended by this act shall allow for the development of a transit community middle housing development as defined in section 11 of this act, the 2 to 9 units, or a mixed use development on any lot that is zoned for commercial or mixed use development, subject only to summary review as defined in section 8-2R as amended by this act, and 2 may allow for the development of a transit community middle housing development on any lot that allows for residential use subject only to such summary review. Now, there is a section later on in the act that does speak to conversions, but it again only indicates that should the commission adopt that section, that it opens up gray field funding from the Department of Economic and Community Development. That's the only portion, and it amends a very small portion of that pre-existing PA-164.
This reading does not appear to be limited. It's written in plain English, and it seems to say exactly what it says, which is as of right conversion without any other restrictions. So I would really like to have the town attorney give us an opinion on that.
A municipality that adopts or has adopted zoning regulations pursuant to section 8-2 of the general statutes as amended by this act that allow for the conversion or partial conversion of any commercial building into a residential development pursuant to this section shall be given priority funding by the Commissioner of Economic and Community Development under the Grayfield Revitalization Program established pursuant to section 112 of Public Act 25-174. There's nothing in there that says we're required to.
Was that section that you just read a different section than section 16?
Yes, that's what Ms. Harrigan had indicated already.
What section did you just read from? Was that 16 or
From
something else?
Section 40, I'm sorry, no,
41?
It's just a section about funding.
that's what
I
Commissioner.
don't see,
She's not talking about funding. She's talking about the conversion.
Yes,
yeah, I
that's,
don't see that as
Is
modifying
in
the conversion.
language
Just about the money.
used. We have to
I don't
allow
see,
development of mixed use. It's separate from conversion. I think there's two separate acts that are being discussed right now.
there's no language that says we have to allow for the as of right conversion.
but the funding does not modify the conversion. So I think, look at, that's why the town attorney in the charter is supposed to advise every public entity, that every town body. We need to get his advice on this, and I'd like to get it before next week.
He already,
Already weighed in, he's provided a written
He's
legal
not
opinion.
advised us on this.
He has
He's not.
provided a written legal opinion, and there was an offer to hold a closed executive session to discuss a written legal opinion, which is the proper channel to do that. And
It
that
is
is
not a proper channel. It violates FOI. We can't have private
False.
meetings
not
about,
true. That is not true. It is not a violation. That's actually the proper place to have a conversation with our town council on a formal written legal opinion that he provided,
But there's no
answering this
pending
this
litigation.
question that you just claimed incorrectly that he did not address.
okay, he did not address this question. We all agree on that.
We
So the
don't-
next question is, can we get him in to advise us on what the law allows and what it means?
Commissioner Braun, this motion has been made 2 or 3 times already. It is not.
I never made it on this
Every time.
section.
if I might through you, Mr. Chair.
I have my hand.
So I've spoken to the town attorney several times. When you have legal counsel with a client consultation, you do that in executive session. If you do not do that in executive session, any other communication that you have between your town attorney then becomes available for FOI. That is why our town attorney believes in order to protect this commission, he needs to have this within executive session. And so he's not willing to meet with you to have this discussion in the public. You are his client. He is your town attorney. Any conversation you have about something that potentially could result in lawsuit needs to happen in executive session.
My understanding is that according to Robert's rule, after pending litigation, that's not the case. And also, Attorney Braun is the well-established attorney in the real estate arena. I want to go on record by saying if she's confused by it and me and wanting to consult a land use attorney on this, we were told that our town attorney was not a land use attorney. It's in his bio that he's a land use attorney. He should be talking to all of us on this topic and also the public. If we're going to be passing regulations on parking, on floor area ratio, on setbacks, on whatever else, traffic studies, we should have him weighing in, they get paid $1 million a year at Cohen and Wolf for these services. If we ask him to meet as a commissioner on this commission, and several of us have asked, he should be weighing in on this topic.
Several
And
of
there's
us
a
have not.
reason, unless there's a reason we're being told, he's not allowed to discuss that with us. There's no pending litigation on this matter. This is informative only. You should be allowed to have that meeting with the town attorney in public, so that the public then can weigh in on any decisions were made based on that information.
Several of us have not asked. Commissioners Monahan and Braun have asked. A formal written opinion was furnished as a result of that request. There was an offer to hold an executive session for Attorney Pierce to provide further clarification and answer questions on that. Commissioners did not choose to take us up on that offer. Commissioner Braun.
He did not render an opinion on exactly the question that came up tonight.
He did.
I'd like, Could someone tell me what it is? Because I don't have that.
That he would meet with you in executive, he's happy to meet with you in executive session.
No, did he render an opinion on this section of the law about commercial conversions? Whether
He did.
they have to be abandoned or not.
He did when he reviewed the regulations that you've already adopted.
I didn't read his opinion. I didn't hear his opinion. I didn't get his opinion. I need a direct opinion. If I'm the client, I want to hear from my lawyer. I don't want to hear it filtered through anybody else. I think we're entitled to that, and we haven't gotten it.
You've already adopted
Reviewed,
these
I don't know what
regulations.
Yeah.
Commissioner Capozzi?
I would
So
be in favor of meeting with our attorney in an executive session. Because what we discuss may be subject to privilege. And if we don't meet in an executive session as a safeguard to protect the town of Fairfield, we could open ourselves up to potential litigation and discovery that we do not intend to do. That is why the attorney is advising when we speak to him as his client, we do so in a private executive session. It's the practice of this commission and always has been, at least since I've been on it. So if you want to meet with the attorney, I would be in favor of doing that, but in an executive session following the attorney's advice.
Commissioner Monahan?
There's no pending litigation. This is informative only. This is just the interpretation of the law as it applies to everything that we're passing.
If there is
I
a
would-
chance,
all right,
if there is a,
hang
no,
on,
I want to say
Commissioner-
this,
no,
I
Commissioner,
want to
you're out of
say
order.
this,
You're out
if
of
there
order.
is, I don't,
Capozzi, you're out of order.
may I speak?
No, you're out of order. We're not, commissioners should not be addressing other commissioners directly.
Fine, I'll address the room. There is a chance that meeting with our attorney in a public forum could subject this town to unintended consequences that could cost this town millions of dollars. I do not agree that we should flagrantly and performatively, frankly, go against the attorney's advice and meet with him in a public forum that opens the town up to liability potentially. And anything else, I'm sorry, is a performative stunt designed to make it appear as
All right,
though the
well, hang on.
minority
Wait,
is doing
hang
something
on.
that they are not.
Commissioner Capozzi.
That's my
you know,
opinion.
I object to
Hang
that
on, hang on,
characterization.
Commissioner-
There's no
Commissioner
need for
Braun,
that.
Commissioner Braun, let me handle this. Commissioners should not be calling into question the motives of other commissioners. Argue against the point, not the motives, please.
I said what I had to say.
Commissioner Braun. Go ahead, Commissioner Monahan.
I'm going to make a motion to get a written legal opinion by the town attorney on what is required in the proper interpretation of section 16 of the housing law, as he's given for other matters which are public now.
Staring at his legal opinion on that question.
Mhm.
It exists already. We can.
I haven't seen it.
circulate it.
Where is it? I have.
Been sent- Commissioner Braun. It's been sent to the commission, so we can recirculate the letter.
Is it present now? Can somebody read it? Because I've never seen a letter that
Commissioner
answers
Braun.
my question.
Commissioner Braun, it is a formal legal opinion provided it's a privileged document provided by our town attorney. We're not going to read it into the public record right now. That's incredibly inappropriate.
The interpretation of a state law is not privileged. I'm sorry. And that had to do with whether we
Braun,
could.
you were an attorney yourself. You should know that a written legal opinion provided by an attorney is a privileged document. I'm not sure how there's any confusion about that.
I don't agree.
So
And
it's
that
fine.
did not cover the question I asked. My question has to do with whether
I said you
the
have not
property.
read the document, that you're not aware that it exists. I'm not sure how you could say that it doesn't answer your question.
I read a document, but it didn't answer the question that I asked tonight. That had to do with whether it could be mixed use or residential, or had to be both. I'm asking a question about whether the building has to be abandoned to be converted. That was not answered.
Commissioner Braun, would you like to discuss the proposed parking conservation mitigation zone?
I made a motion. Is there a second? I made a motion to submit my question to the town
Dilatory
attorney.
motion. A
It's
motion
not
that
dilatory. How could that be dilatory?
Because it's been made and voted on multiple times. This very
So you're
motion,
disallowing me from making a motion?
making a motion that has been made multiple times. An
No,
identical
I've never made this exact motion before.
Commissioner Braun. This motion to seek an opinion on this item from the town attorney has been made.
We
No, it's
started,
not.
we
It has
started
been.
in March requesting something similar.
And in April.
Why don't we just have an executive session with him and ask him whatever you want to ask him?
We've made that offer. We're happy to have it.
I don't understand. What?
So I want to add one thing. We are
Commissioner Monahan.
we are the only town. There are several other towns that have broadcasted their meeting with their town attorney and their members of the community and other representatives on this topic for them to be able to go and ask specific questions about this law, why our town is different. We're the only town that's holding executive session on this topic. I don't know.
And through you, Mr. Chair, if you don't mind. John and I are both planners that are certified planners that every year are required to do training as part of our certification, one of which is an hour of legal training. Every year, the Connecticut Association of the American Planning Association puts on an event where they talk about cases that have been decided at the Superior Court, at the Appellate Court, at the Supreme Court. Every single year, there is at least one case for the town of Fairfield, usually many cases before the town of Fairfield. We are a very heavy litigated board, and it's a lot of things that come before this commission. It is understandable that our town attorney does not want to have these conversations in a public setting, considering how often we have legal challenges. It's just not prudent. Because we have so many legal challenges year after year after year.
We should not ask questions of our attorney.
And in executive session, absolutely.
And anything discussed in executive session is
Privileged,
privileged. Exactly.
yes.
Commissioner Braun, would you like to present your proposed district?
I would like to know if there's a second on my motion.
Second.
Commissioner Monahan. All those in, anything further?
What is
I
that?
want to say, first of all, my
Do-
question has never been answered. It's a very simple matter to get an interpretation of a state law. That's not privileged. And I don't think you could be sued over interpretation of what it means when you have two apparently conflicting provisions in the state law, what the proper interpretation should be. And I think it would be a violation of FOI for us to agree to go into a private executive session. I think our town attorney knows well enough what he should and shouldn't say in public and what could be privileged and what is not privileged. An interpretation of a state law is something that we need and the public needs, and we need to have it. So
Commissioner Monahan.
Second. I think we need legal counsel on this matter from our town attorney and public. I think it's important that people really understand the ramifications of all of these, these laws that are coming down the pike and how we can protect against it and how important it is that the district that Commissioner Braun and I created should be adopted because the ramifications are significant if they're not.
Hang on, if there's a motion on the table, any other commissioners? All those in favor of the motion to request a legal opinion in public on section 16 of the statutes, please raise your hand. All those opposed? Fails. Ms. Harrigan.
You've already taken your vote. I mean, if I can just add something additionally to this. There has been a lot of educational sessions on this public act. It is well known that this public act will be more refined by court challenges. And so it is crucial in a high litigation community like Fairfield that you know, we have these conversations as privileged. If there's going to be testing ground for projects that move forward with the regulations that, you know, kind of utilize sections of our new regulations, whether you push back on some of what's in the regulation or an applicant chooses to push a little bit in one direction, there may be appeals on either side. Any of the panels that I've sat on that have included attorneys understand that there will be legal challenges with this new state law. So again, I think protection of the commission is really the first thing that we should, you know, be mindful of.
Thank you, Commissioner Capozzi.
I'd like to make a motion that we have an executive session with the attorney, which is consistent with the attorney's advice and with the advice of Director Harrigan.
Not sure we can do that. Now, we can create a motion to go into executive session when we have it on the calendar. We can't put it on right now.
I know not right now.
We'll have it. We'll schedule it and then we'll have a motion.
Well, can I make a motion that we schedule the executive session with the attorney?
Sure.
That's about right.
Yeah.
Sure. Is there a second? Excuse me, Commissioner Delgado seconds. Any other questions? All those in favor of the motion to schedule an executive session with Attorney Pierce to discuss Section 16? Raise your hand. All those opposed? Okay, so motion passes 5-2. Commissioner Braun, would you like to present your district?
I would like to ask if Commissioner Monahan would like to, or if she would like me to. We have a big write-up here and
Why don't you
whatever
start,
she-
Commissioner
Pardon me?
Braun? Why don't you start and then I'll.
Sure, okay. So I've just, as a little bit of a preface, I've been emailing Commissioner Randolph a couple of times, and one of his complaints about our proposed districts is that it is not consistent with the POCD. So that's a big issue, and it is completely consistent with the POCD. So could somebody put the district that we sent today on the screen?
Yep, John will pull that up for you. The one that they sent, not the one that you did.
Oh. My apologies.
The one I have is blue and white mostly.
Yep, I have it.
Okay, and Mr. Mullins, you've had a chance to look at this, and can you just give us an update? Because I know you've been working on it as well, and I haven't been in that loop today anyway, in terms of it's just under 4%.
Yeah, your number, my number was a little different than yours. Mine was just a little more. Yours was at 1.03 square miles. Mine, when I did my math that you see up there, it came out to like 1.08. But yes, it's generally consistent with the number that you guys came up with for.
And just for methodology, what is the area of the town of Fairfield?
Well, can I find the map while I can't do?
Sure, absolutely, yeah. I had 31.4 square miles, but I think it's a little bit less than that.
I think it's 30 square.
I think it's
Pardon me?
3454.
30.454. So 4% of that is just a little bit over 1 square mile.
1.218.
1.218, correct. Yeah, that sounds about right.
Yeah.
So we sent in a couple times, and you've confirmed that the district, we only picked one district, and we picked what we considered the most important district to preserve, which is basically the post road from approximately South Benson into Southport and extending down all the way down Reef Road, portions of the upper beach area near the old post road, and much of Southport. And I believe, and Commissioner Monahan, correct me if I'm wrong, because I've been busy with other things today. We took a little bit out of part of Southport near the waterfront because we included the area, the square foot area under the roads in the calculation. And because again, I've never known of passing a district or creating a zone or a district that has to be limited in size. So it matters when you build it from the parcel size up. Are we including roads? We did exclude I-95 and the rest stops. And we drew it to exclude areas that we did not feel would be prone for development, such as schools or, the town campus. We excluded Mosswood, I think, different things that are already filled with multifamily development.
Yeah, I know which one's a listing of exactly what we excluded.
Yeah.
We included the central business district and the
Mhm.
post road from the Fairfield Circle interchange south of Reef Road and the Southport Historic Village. Exclusions, I-95 and the rest areas, the railroad, areas, cemeteries, civic facilities, including the sportsplex, existing multi-unit residential, and the Commerce Drive area, because that's part of the town's transit-oriented development study. So those are the areas that we excluded and included.
And the overarching theme again is basically several criteria. One is what seems to be most likely where somebody would want to build multifamily. It doesn't have to be commercial conversion. It could just be multifamily where it could happen. And commercial conversion just adds another layer to our discussion because that goes into effect on July 1st, but it doesn't have to be commercial conversion. So where is in a likely area where somebody might build multifamily and provide inadequate parking? So we started by drawing a half-mile circle around the 3 train stations. We did not use Metro Center because of a variety of reasons. First of all, that is already subject to a CMDA, which is the Municipal Redevelopment Program that was entered. So it seemed like if we tried to do something different there, it could conflict with that perhaps, but also that's a different type of area that's already sort of in the plan to have a great deal of development with its own parking scenario, and it has a much greater capacity as well. So we picked the downtown train station and the Southport train station as sort of a starting off point. Those circles are about half-mile radius each, right, around those train stations, which is generally considered sort of a transit area. And we then and actually when Commissioner Mana and I did this using a cell phone app, we only have the ability to draw a circle. So we drew 2 circles along the post road, which included a whole lot of stuff that didn't have to be included. So now that we were able to get somebody who's a professional with, it's called QGIS software, to build this up parcel by parcel. So you could actually go down to the parcel, and Commissioner Monahan knows more about the technical part than I do, but you could actually get a list of every parcel, I believe, that's included in the district. So we were able to use our sort of judgment on what's likely to be developed, what's not likely to be developed, and where is the biggest problem where you don't want to have an overflow parking situation. And on top of all that, we were very concerned with the small businesses that populate our downtown. Because first of all, we do have that commercial to mixed use as of right redevelopment that could take place starting on July 1st. And that, of course, could affect anywhere on the post road in our commercial areas. We also had passed a zoning regulation a couple months ago, which allows more density, more floor area ratio, more height, 52-foot tall buildings, which is basically 3 floors of residential over commercial. And even though the state law says that commercial conversion would be a 9-plex, I honestly don't know if somebody could put more in without taking advantage of the commercial conversion. It could potentially be more. I don't know that there's a limit on what you could do. If you don't choose to use the commercial conversion law, you could just perhaps apply for it. So we were very concerned because we know about the parking problems. There was a survey done by a member of our community online, and they got almost 700 responses, and a lot of people came and spoke to us, and the vast majority of them, despite obviously people wanting to protect their own neighborhood with the ability to preserve parking, the vast majority, I think it was around 90%, wanted to preserve the small businesses in our downtown. And I've actually, I don't know if Mr. Barnhart is here, but I would really, really like to hear from him because I did have a casual conversation with him. And yeah, there's parking problems, and we could potentially find parking and do a parking study, but right now, we need to do this now. So we should not be waiting, and we need to make sure we, take care of this before July 1st. Because if we wait, something could come in and they don't have to provide enough parking. And it might not be likely, it might be likely. Who knows? I can't predict the future. All I know is the 830Gs out there, there's pretty much overflow on a lot of them. There's parking problems with them, and they do have parking. So if we can't require any parking, then we have that problem. And I've heard basically 4 sort of arguments against having any parking in the downtown center area. I don't know that there's any data to back those up, but I don't agree with them. And one is that there's a market for carless living. Well, there could be a lot of people living down there, and that's not my concern. That people might want to live without cars. There would be people with cars, and if you allow 3 floors above commercial, you will have overflow parking. You will have a problem. And another argument was that, and we've heard this tonight, that developers can't finance or market their projects if they don't have enough parking. I don't know how that works. I'm not a finance person, but I do think that even with 830Gs, we have overflow parking. And when you have the cumulative effect of perhaps a number of these, it could happen. And we really have a parking problem right now. And the other is that we haven't had a lot of activity with flipping so far, but the laws go into effect at the end of this month. So once that happens, there might be more. You can't really predict the past from the future. We've changed our regulations, combining those with the new law, I think could lead to applications. And that's why it's critically important that we preserve what we can. And the only question is, should we preserve the downtown area? This is the area that has the biggest parking problem. And that's what everybody says. And I don't think anyone's done a survey of the small businesses, but we certainly don't want to risk it. People come to our town, they love the downtown area, the ambiance, the sort of small town eclectic businesses. They're very upset. I see it all over social media about what's happening at 15 Uncle Road. And you can see more things like that happening. And again, the cumulative effect is a problem. So that's why we focused on this, and we consider this extremely high priority. And we can go delve into how it is consistent with the POCD. I'm going to let Commissioner Monahan go into some of the details of the parcels and the decision making about them, because she knows more about real estate. And by the way, just to answer Commissioner Randolph's question, I don't own anything in downtown, neither does my family. So this has nothing to do with me. So
I also think it's important to note that 2 of our sections also include the historic area of our town, which is very important that most people feel the need to protect. Additionally, I don't think a lot of people understand the decisions that were made in the past 6 months between the changes in the POCD with building height, allowing 52 feet, encouraging it really between Saskell Hill Road and South Benson Road. Floor area ratio, which allows buildings to be built that are bigger on a parcel. The setbacks from the road. I don't think a lot of people know there will be no more parking if a new building is being built. There'll be no more big, large courtyards or parking in front of buildings. So that is, a lot of developments in town that we all really like will not be rebuilt in that same manner. They will be only a few feet from the front of the post road, and the parking will be in back. So very important. I see parking as the last thing that developers need to say, I don't have to show a parking plan. Now with even the smallest parcel, it can be built 52 feet into the air. So it is more important than ever that we look to protect the charming smaller buildings and the single and 2-story buildings in town that we all know and love. And we do not want them all being replaced by 52-foot tall buildings. Additionally, I'm also concerned because there was a House bill that was voted on May 1st of this year that all 3 of our state reps voted for. And it essentially said that it hasn't gone to the Senate, but it did pass the House. So it will very likely come back in the next session or be buried in another bill. But it essentially says that we don't have to, If you want to build an apartment building, it does not have to have ground floor commercial. And so add that to the mix. If that comes back, right, future, I know one of your meetings you talked about, you don't know what's going to come down the pike in the future. If that comes down the pike in the future and that's mandatory, and we do not protect these, parking areas, we will now have apartment buildings on the post road with no parking. In the day and age we're in, I don't know if anyone has a Tesla and they summon the Tesla to pick them up. You can park your car in the train station and take train station parking, if you have a parking spot, and you can summon the car to pick you up. It doesn't mean that you're not going to have a car. Several large cities in the United States are decoupling apartment buildings from parking. So they're not always offering a parking spot with the apartment for rent. So, and I'm talking about rental apartments. I'm not talking about condominiums. Condominiums are more likely to be built with a parking plan and a garage, but I'm talking just about apartments. So together, all of this combined, more of a reason why we as residents of this town, who are also commissioners, should want to protect the downtown. I don't think there are many people in town who know the ramifications, the true ramifications of this bill. So I also believe that it is, what we're proposing is just protection. It's protection for people who want to visit the downtown, who want to travel downtown. It's for the store owners who are downtown, who want to make sure that people actually come and visit their stores, their restaurants, their, whatever their service provider is. It's also to say to existing people who live in town, this is important to you and it's important to us. Adding additional housing downtown, which I believe this is just all about adding apartments downtown, is a wonderful idea, but at what cost? So I believe that we should be looking to the quality of life, and according to the POCD, and we're happy to kind of get into that, why our parking mitigation districts are also consistent with the POCD. But it's important that we protect why the things in the town that the people already enjoy and love, and that are important to the character. Do you have your hand raised, Ms. Commissioner Braun?
I'm talking after you're done. Don't worry, I'm not going to interrupt you.
Okay. So, why don't you go to you and then I'll talk about the POCD.
Yeah. So a couple points that triggered me just now. I'm looking at the map that's up there is actually not the most recent iteration. And I know there's been a lot of maps flying around. I just want to hold up what is the most recent one. You can see part of Southport we had to carve out. Could Mr. Moans possibly bring this up if he has it? Can you see?
Oh, it literally disappeared.
Back. Yeah.
Mr. Monahan, can you show me which one?
Okay, there's a little bit of Southport that should be carved out because when we included the interior roads, they have square footage area, and because this is a parcel up, exercise where we went by parcel, obviously a parcel does not include a road. So we had to reduce it a little bit from what we thought was just around 4%. So we wouldn't exceed 4% when we included the interior roads. So the map that you're looking at is not the most recent. I just for illustrations purposes, obviously in the record, everything is there, but just so you understand that. So it's not an easy project because you're using QGIS software to build it up parcel by parcel. That does not include the square footage of the roads. And arguably, the statute doesn't say what has to be in or doesn't have to be in, but since it is a 4% of the town zone, I assumed it should include the square footage of the roads, even though it's a parcel by parcel analysis. So the first time we did this, we weren't going to include it. Then we decided to include it. And we thought if we included the roads area, we have to take a little bit out. So that's one point I wanted to make. Another point is there was another sort of argument in favor of not having parking in the downtown, and actually two more. One is the beach area needs more, and I agree. I would love to protect more of the beach because there is a lot of duplexes going in down there, and there's a big parking problem. But this is parking zone number 1 that we proposed. We consider this the highest priority, and we lucked out because when we finally put this together and carved out the areas that don't have to be protected, we were able to cover a larger footprint within the 4%. So our first stab at this, if you will, using the cell phone app, did the area that we're sort of protecting was the whole 8%. This area I'm showing that you have is 4%. So there's a whole other zone that could be done. And I leave that up to the commission to decide where that should best be. It should perhaps be sort of surrounding this in the beach area, especially, or maybe it should be somewhere else. I don't know. We picked this because this is the top priority that we feel is critically important for our town. Another issue that that's been raised in terms of why we should not preserve parking downtown is that if, when the town was first developed, 80 or 100 years ago, there were not very many cars. And so if a building had a casualty loss or had to be restored, it really couldn't be done, but there was a way around that. And I do believe the regulations we just passed allowed that. The regulations we just passed that have to do with parking 2 months ago, in one of the sections, and I believe this was passed along with it, 25.13.3, parking flexibility in the center design district. It says the center design district is Fairfield's historic commercial center with many buildings constructed before the advent of the automobile, where added parking services are challenging to provide without sacrificing the vibrant pedestrian-oriented nature of the center. Existing buildings, as of the adoption of these regulations, may convert to new uses without the provision of additional parking, provided the footprint of the structure is not expanded. All parking alternatives in this section, such as joint usage, et cetera, are permitted by right. And public lots within 1,000 feet may count. So we're allowing for shared parking, but we also have flexibility to not mandate that if somebody has to restore their building, if it's now legally non-conforming because it predated, without parking, it predated our regulations that require parking. I think we have the flexibility of allowing something to be rebuilt if we don't change the size in the center district. And that's what we could do, maybe go beyond what we have in these regulations. So that's my thought. And, so I don't think those are valid arguments to not have any parking in the downtown. And again, from talking to even Mr. Barnhart and other people around town, it's a problem. It's a problem right now. It even came up with the Board of Finance a couple weeks ago. I watched the meeting. If you have businesses that are strapped because people don't patronize them as much because they can't get there. And we all know people will drive around for a long time to get a close by parking space. Then that could affect business success. It could affect our, business personal property taxes. And it could affect, it could lead to businesses failing. And it could cause us to have to build a parking garage with public funds to subsidize private development that doesn't have adequate parking. And again, no one's going to try to not have adequate parking. You don't really know. I find with any development that there always seems to be more parking needed than is provided. And if we allow cumulative effect of redevelopment, commercial conversions, or multifamily development without preserving it in this area, I think it could severely affect our downtown businesses. And that could lead to a financial adverse impact on our town. So that is why we picked this as zone number 1, the most important one to preserve. And I'll let Commissioner Monahan speak again. And then one of us should address how it is consistent with the POCD.
Commissioner Brook, can I just jump in with a question?
Sure, yeah.
The Southport area, the memo or analysis that I'm sorry, I forget which one of you emailed over, that was called Monahan and Braun staff draft first evidence. So that sort of looked at the previous proposals from staff and sort of some of the survey feedback and other considerations, I guess, and gave some explanation for rationale for your proposals. The one part that I was just a little unclear on was Southport, because it looks like the memo talks about, or the analysis talks about how the Southport Village and the surrounding area and the Southport Metro Station area, it seems to suggest those are or candidates for inclusion, but it looks here like you include those. So can you just talk a little bit about I thought you were going in a different direction when I saw that analysis, but then Commissioner Monahan clarified that the intent was to leave, though I think the intent was to leave those parcels in. So can you just talk a little bit about that?
Oh, well, my understanding is that my map is the most recent one, but we can clarify that. Yeah, I'll ask Commissioner Monahan about that because my understanding is that this was taken out to allow for the roads to be included.
I think what you're holding up is what's on the screen. My question is really,
No, it's a little different. Yeah, it carves out a lot of Southport, part of Southport down there at the bottom.
No,
Some
just to be
lots
clear,
of-
this is the one that I pulled off the email from Commissioner Monahan this afternoon. So this one here is what,
That she's the one that you have up there. Is that the one
That's
up
accurate?
there before? That's the one I believe that is accurate, but I'd have to look at, each additional.
so
Overlay.
not so much on a parcel by parcel basis, but I'm just curious,
Some of the lots.
without an opinion for or against, why it seemed like you were going in a different direction in the analysis that you didn't want those included, but then but ultimately kept them in.
So
I think-
I think it's really important if someone is going to have, well, first, it's the value of the lots and the land are significant. They're already developed. They have large freestanding homes on them. A lot are in the historic district. Secondarily, the ones in and around the train station, which are probably the most desirable for a developer, are already owned. And, there are plans for most, if not all of them. Anything we did not include in those already have plans for the property. In terms of, we went out from a certain distance from the train station to say, these are the most likely targets where someone would park at the train station, keep their car there, and then we went out kind of, from that area. So the parcels that are the closest to the most beautiful, significant, entertaining, visited, commercial areas of Southport are all included. And then we went out from there, given that we,
Okay.
the two parcels, importantly, we had to connect the two areas because this has to be one area. So we had to connect both areas from Southport to Fairfield in order for it to be a litigious, contiguous map.
Okay, so perhaps the analysis reflects previous thinking, because that was my only confusion, because it seems to make the case against including those parcels. So we'll focus on the map then.
Interpretation.
Yeah. The overarching theme is we're trying to convince our commission that generally this area, the outlines can be adjusted if need be, but I'm trying to convince the commission we need to preserve our downtown for parking. And the arguments against it, I don't think hold water. And I would like to hear from Mr. Barnhart what he thinks as well. I know he's going to be doing a parking study, but we can't wait for that because applications could come in. We need to preserve the parking now. And then, hey, if the park, and a lot of the parking that's available around town, some of it could be private, and it might be very difficult, if not impossible, to force private owners to make their parking available for the public to use. So that could take a while, especially if you're getting financing with MetroCog to assist. So this is something that I think we just need to do now. And as Chairman Corsillo pointed out, it's not a deadline. Our own deadline should be self-imposed. We want to preserve this before applications start coming in. After July 1st. I don't know if they will or not, but I don't want to be caught, unprepared. So we need to do this now. And then if at some point there's a parking study which shows, oh, there's a whole lot of stuff you could do to move parking around without us having to build a $20 million, parking garage, that could be in the future. We can adjust it. But right now, this is critically important in our opinion. And again, let's do this. Let's do the second zone. Maybe that should be, abutting this. I don't know. Whatever the other commissioners feel it should be. Initially, I thought maybe we should just do the whole 8% at once and draw a line down the middle. That could be done too. But this being the most critically important part for the viability of our downtown, which is a huge draw, as Commissioner Monahan has pointed out a number of times, I'm not a real estate agent, but she knows this area. She knows what draws people. They love it. So that to me is critically important of what we should be doing.
Commissioner Churchill?
I have a, first of all, comment and then a few questions. So the point was raised earlier, I believe by Commissioner Monahan, that documents inserted into the folders and the public records need to be appropriately labeled with drafts, which I completely agree with. I'm wondering if we can, I don't know if this needs to be an official rule, but like I'm finding it very confusing when I'm looking in this document and I see Braun and Monahan's circle, Braun and Monahan's other circle, and there's different maps that Braun and Monahan have drawn. I'm not actually sure which one is the right one that I should be evaluating. So maybe if we could label and have dates or just organize it in a way that makes it clear. At this point, I'm so thoroughly confused about what the districts are, or what we're actually considering, that I don't know quite what to think.
So that's great that you asked, because if you, and I'll send you the file.
Yeah.
Click on any point on any map, it'll show you who owns it, what the lot size is, what zone it's in, how large it is, et cetera. So
Yeah.
we may be just looking at a flat piece of paper, but if you'd like to have essentially the 3D version where you can click on it and it will go deeper in, I'm happy to send it to you.
Yeah, can I finish my, yeah. So the other questions that I have concern a document that was entered. I assume this is a memo that Braun and Monahan have submitted. Let me make sure I get the right. Monahan and Braun, it says, and it's the one staff draft versus the evidence. I'm just wondering where all of the data that is cited in this memo is coming from. And again, I would just ask that this be very clearly labeled, that it is a memo coming from Monahan and Braun and that it is your opinions, because when I read this, it was not clear to me who wrote this or why. But it's citing data. I don't know where that data is being pulled from. There are no footnotes or endnotes that I can look at and double check the data for myself. It's also citing, I'm sorry, I'm still speaking. I'm looking, for example, at data regarding the pricing per acre. Usually I'm an academic, so when I'm looking at data, I expect there to be a footnote or endnote so that I can double check the data for myself. There's also citations in here about surveys that came from the public. There's no link to that, so I don't know where that information is coming from either. So I'm just wondering if this document could possibly be resubmitted with those links so that everyone can double check the data and understand what you're citing.
Absolutely. Happy to do so.
Thanks.
I want to add,
I do. Yeah.
I want to add one more thing. I also think it's important that any other data put in about the parking that we have currently downtown is also qualified, and that any other parking studies that are submitted, that they're also kind of vetted, and that additional studies should be kind of pointed out as well. So, I'm talking specifically to the Marshall and Garrick 2006 study, which was the only study in the compilation specific to small New England mixed-use centers. And it found that successful walkable downtowns, Brattleboro, Northampton, West Hartford, operated on-street parking at 98.9% peak occupancy and municipal lots at 85.3% peak occupancy, because the town rigorously managed shared municipal parking lots with meters, pay and display, enforcement and consolidation. And I just want to make sure we note that we have none of those management tools in place. That literature doesn't say minimums and it will work out. It says eliminate minimums after or in combination with active municipal parking management. So I just want to make sure that other things that are noted on all topics, I agree with you, should be qualified and vetted before they're just posted. So I'm happy to do so going forward.
Mr. Chair, can I ask if Mr. Barker? Oh, sorry. Yeah.
Can I just ask, it's, as you know, Mr. Barnhart chairs many commissions in town. And if we could get to him so he can go home to his
Sure,
family.
yeah.
Expect that
I was
for-
just gonna ask if he was here. Great,
Like that.
fabulous.
One more thing before he talks, you know, we don't talk about safety when it comes to kind of parking. And I just want to make sure that we noted that the post road around downtown, and this is according to the POCD, the Plan of Conservation and Development that was recently adopted, page 46. The post road in and around downtown is home to a large number of crashes, especially pedestrian involved crashes. The area is home to some of town's most walkable businesses. Exit 24 as well is I-95 that intersects with Route 1 is the location of considerable number of town crashes. So when we look at these traffic mitigation districts, it's also very important that we're looking at documented crash concentration as areas that we are trying to protect against. So just to that note, very excited to hear you talk tonight.
Mr. Barnhart, come on up. Thank you for joining us.
Thank you for having me. I'll bring my suffering from some allergies with the pollen, so appreciate it.
You want us to bring up that map or do you want us to wait?
No. So my understanding of tonight in terms of the purpose of the hearing was to consider the establishment of two conservation mitigation districts parking.
Could you speak up just a tad? Some of us have trouble hearing you. If you could speak up a tad.
Sure.
Thank you.
So for the record, Mark Barnhart, Director of Community Economic Development. My understanding why I was asked to come here was to talk about the proposed parking mitigation districts that are being proposed. The Economic Development Commission did consider this matter at its most recent meeting, and there's a letter in your file, I believe, that discusses this. Generally speaking, we'll leave the actual boundaries of the proposed districts to you, but our understanding was generally we're talking about a district in the Southport area as well as one in the center area, which could encompass parts of Reef or Beach Road. The commission was generally supportive of those changes, and I'll just say that, again, we're talking about what the purpose here under Public Act, as I understand it, is that this would reimpose or establish parking requirements for a small subset of proposed developments, that being residential developments of 16 or fewer units. Sorry. Thank you. For which you would need to, if we establish these conservation zones, provide one parking space for a residential dwelling unit of one bedroom or studio, and 2 spaces for anything larger than 2 bedrooms. It also provides an option, as you probably well know, for there to be a recommendation from a parking needs assessment. And you're then, if we adopt these standards, to take the lesser of what's recommended by our parking requirements. 1 space for studio and 1 bedroom, 2 spaces for 2 bedrooms or more, or what's recommended by parking needs assessment. I would agree with some of the statements before. I'm not seeing a rush of new development applications for this type of development. But, you know, erring on the side of caution, I don't see an issue in terms of adopting these minimum parking requirements as it relates to this particular subset of development activity. I don't know that it would have a significant impact one way or the other. Ms. Harrigan talked earlier about development market pressures. Every developer I know is interested in making sure that they have a profitable project, a project that earns money. And in order to do that, you need to provide a product that you can either sell or rent, and that people are looking for. And in this particular marketplace, I think there's an expectation that if you're providing a dwelling unit, there be at least one parking space associated with that dwelling unit. And I think you've seen that. Harrigan noted 830G applications, which are not required to follow our regulations, parking or otherwise, that provides at least one space for each unit. Whether that's fully adequate, because some of those developments also include 2-bedroom and 3-bedroom units, and they provided the bare minimum in terms of 1 or perhaps 1.25 spaces per unit. That's debatable. But again, they all provided some level of parking, and I think that's likely to continue. There was discussion, I think Commissioner Braun mentioned not understanding, perhaps the process by which developers have to consider these things. And maybe I'm mistaking what she said, but developers, obviously they are mostly working with other financing, not always using their own resources. So they have investors, they have lenders. Those folks obviously look for ways to ensure and mitigate risk. So there's oftentimes insurance involved. And all of those parties also want to make sure that there's a reasonable allowance or accommodation for parking, such that the product can be sold or leased up. So again, I think for the most part, I can't say there aren't irresponsible developers out there. There certainly are, but most developers are going to provide something that, again, will be financeable and will ultimately provide a reasonable return on investment that will be received by the marketplace and thus will provide some allowance for parking. But again, we're talking about establishing a mitigation district or 2, Southport, center town, that would establish a minimum parking requirement for 16 residential developments with 16 or fewer dwelling units within them. And I think that's fine. I don't see necessarily a downside to that. And again, developers would then have the option, if they didn't feel like there were circumstances that applied to their particular site that warranted something other than 1 space for a studio or 1 bedroom and 2 spaces for 2 bedrooms or more, they can provide a parking needs assessment to make that case. And then you have to consider that. So, the Economic Development Commission, when looking at that from that level, I think is generally supportive of the concept. The areas that are mentioned, talking about specific streets or parcels, those areas, okay, we can see the rationale or the thinking behind it. The issue of a parking study is a separate thing entirely. And I will note that, every business needs parking. It's a top level concern. I mentioned that. The commission mentioned that in their letter. I have long worked for the town. When I first started working with the town, I was asked to serve on a parking committee. That was a subcommittee of the parking authority, which was part of the police commission at the time, traffic authority. And parking was an issue downtown at that time. We talked about it. We didn't have the resources to do a full-blown parking study, but we were looking at some of the same things you're discussing here today. So that's been also will note that what we love about the downtown largely predates zoning. And many of the businesses that are currently there would not be there had it not been for this commission and the Zoning Board of Appeals taking a more enlightened and flexible view as to how it will enforce its own parking requirements. Most of the restaurants exist downtown by virtue of a variance. And I've long maintained, and when that's no longer the exception to the rule, but the rule itself, maybe it's time to consider changing your regulations to allow what we do like. You know, we have a very vibrant dining scene, outdoor dining. People love that. But again, most of that would not have happened had we not taken a more flexible view in terms of how we enforce our own parking requirements. And that also pertains to other businesses, including our, two entertainment venues. Again, both of those exist by virtue of variances that have been granted by the Zoning Board of Appeals. So we don't want to throw out the baby with the bathwater here. But I do think, this limited, what we're talking about, very limited, applies only to residential developments of 16 or fewer. It imposes then a minimum parking requirement, or you have to consider a parking needs assessment. That seems reasonable to me.
Commissioner Levy, Monahan, Braun.
I will also note the parking study that we talked about. Yes, it's something that we've long discussed. It's in your POCD. You recommend having a parking study. We concur. The Economic Development Commission is willing to put dollars toward that effort. I did have some preliminary conversations with MetroCog, our regional planning agency, to understand what resources might be out there. We believe there might be some planning dollars that can assist us. So we think that's a prudent step, but it has not really any direct bearing on what we're talking about tonight. And I will be happy to share one of the things I did want to provide, because it is instructive, and I'll share that before I pause.
Is that
So one of the things that is the map.
Okay.
So I did ask MetroCog, please pass that down. Thank you.
Public or private?
Oh, this is public.
No, I
It'll be
meant,
part of the record.
I meant the lots. Are they public or private lots?
Both. So one of the things when I talked to Metro, I just want to understand what resources are out there. And they said, well, we've already digitized all the parking in downtown. We have a parking inventory. And so I asked them to provide that, and that's the map. And I said, well, could you give me an idea of what percentage of the land is reserved for parking, surface parking? And it represents about a third. A third of the central business district is parking. Now, obviously, all that is impervious surface. We have to deal with the water from that. Or the issue we have downtown is flooding. So we have inadequate storm drainage systems. So, there's also environmental considerations here with the amount of area that we've reserved for surface parking. This represents 2,676 parking spaces, some of which are private, some of which are public. The parking structure at the Fairfield Center building it's not included. But if you include that, there are 271 spaces there. That brings us close to 3,000 parking spaces. This does not.
2076 plus 271?
Is 2,947.
Well, I just got 2076 parking spaces and then 271.
It's 2,676
676. Thank you.
with the parking structure at the Fairfield Center building, 271 equals, if my math is correct, 2,947. There are an additional 1,016 spaces at the Fairfield train station, which is not on this center design business district. It's zone designed industrial. There are further 141 on the Mill Plain lot. There's 325 spaces at the Fairfield Rec Department Sportsplex complex. So if you add all that together near downtown, it's 1,400, an additional 1,482 spaces. So my point is, there's a lot of parking, a lot of area reserved for parking. So why do we still have parking issues? So that is the purpose of looking and doing a parking study, because some of it may not be very well laid out. It may not be in areas where we need parking, may not be, there are certainly rules and regulations in terms of who can use the parking and when they can use it. So again, the commission's already looked at shared parking arrangements? How can we provide strategies or tools to allow people to use more parking more flexibly? I think all these are good topics for a parking study. First of all, to look at what we have, look at how we can better utilize that and make it accessible to folks. And then look for opportunities where we can augment where necessary. So that's my parking study.
Thank you, Commissioner Levy.
Yeah, thank you, Mr. Barnhart. I'll admit I have the luxury of being within walking distance of the center of town. But the other night coming back from Westport, I drove by the parking garage behind FairTV on Saturday night at about 8:30, and it was almost empty. So my question is, I know we don't have a parking study, but you deal with many of the businesses in town. And again, my training says I shouldn't ask a question without knowing the answer, which I don't. But what is your seat of the pants sense of, what are you hearing from your members in the business community as to the degree of concern or the extent of any problem with parking downtown?
It comes up periodically. We meet regularly with our restaurateurs and our downtown merchants, other businesses. Certainly parking is a concern. And when you dig a little deeper, it's not necessarily that there isn't parking. It may not be in the most convenient locations. It may not be in locations that are appropriate perhaps for their employees or their customers. And so there's an expectation, that the parking is going to be in close proximity to that particular business establishment. That's not always the case. But I think when you push further, there's certainly a recognition that there is parking available. You may have to look for it, but that's true of most downtowns, especially downtowns that are successful, that are vibrant, that are thriving. People want to be in downtown Fairfield. We want people to come to downtown Fairfield. So we don't want to perpetuate any concern that there isn't parking. I think we could do a better job of identifying where people should park. That is the wayfinding issue that we've talked about before. So there's a host of things that we can look at to improve the parking situation. I do think we have, based on the numbers, map, seems like an adequate number of spaces. Maybe it's just not as efficiently laid out or as accessible as we might like, or perhaps not in the best locations based on demand. But again, that's not what we're talking about tonight. So that's why.
Well, one other question which relates directly to that is, my 9 years here tells me that developers, whether you like them or hate them, they're driven by the bottom line. They don't want to put something out there that's not going to sell or doesn't adequately serve the level or the nature of a tenant or owner that they want. So to my mind, the biggest concern about not requiring or not needing parking is not, something like the Anchorage on Umpqua, but the situation more like if somebody wanted to build a dormitory along the one of the bus lines for the schools and let the students fend for themselves as to where they're going to park their cars. That's really to my mind, that is the biggest risk in terms of not having a minimum parking. And I don't see that happening downtown Fairfield. I see that in the Reef Road area as a potential concern. Do you have any thoughts on where that might happen?
Again, I think, this particular Public Act 25-1 gives you an opportunity to set a minimum parking regulation as it relates to residential developments of 16 or fewer units. I think if there were a residential dormitory or residence hall, most likely be larger than 16 units, but I don't know that that's something. I think both universities are looking to address that demand, and they have addressed that demand on campus. There's certainly part of the allure of attending Fairfield University is the opportunity during your senior year to live off campus in the beach area. Those opportunities are dwindling, and they're obviously very expensive, so they can only apply to a certain subset of the student population. I think if there is an opportunity to create more off-campus living arrangements for that seniors or graduate students, probably not in the beach area that we want to be encouraging that. I would agree with you. I think, there are other areas where we can see that. We've talked about, the area around Fairfield Black Rock. We have identified that in our POC and our regs as an area where we could support higher levels of density like that. So I think that's probably, I would presume that if we were going to go that route, that would be the area we'd be looking to encourage that activity. But again, I think right now, the universities are more focused on creating that on campus. Thank you.
Commissioner Monahan?
So you said a few things. You said, I don't think this will have any impact one way or another. What were you referring to? Were you referring
If
to?
we should adopt a conservation mitigation district, I'm not sure it would have a significant impact one way or the other. I would agree that not do it seems to me there are more reasons to do it than not, right?
Yeah.
So I think if you're trying to be protective, I understand establishing conservation mitigation districts. I'm just, again, to my way of thinking, some of what we talked about before in terms of Commissioner Levy mentioned, developers are in this not for altruistic reasons, they're in to make money. And so you're not going to make money if you can't sell or rent the product that you build. And at this point, I don't think we're like Boston or New York where you have that detachment from parking versus your living arrangement. People expect, especially where you're paying, some of the rents that these guys are getting, they expect there be a parking space included with that. And I don't think that's likely to change anytime soon. And so I think there is going to always be, at least in the near term, most developers are going to provide some accommodation for parking. It may not be exactly to what you're thinking, and that's why I think, if you set, minimum standards, this is what we expect. It's recommended now. You're kind of making that a requirement for only residential developments or 16 or fewer units.
So this is where I think, I disagree that you mentioned that this only affects a small number of units. It doesn't. It doesn't. This affects almost every parcel.
Oh, I didn't say parcel. I just said it affects developments of 16 or fewer.
But 16 units could be, times 4 bedrooms each. So, and to say that someone is buying something now for tomorrow to develop it is a mistake. Could be 3 years, 5 years, 7 years out. And I don't understand the idea that we wouldn't protect the downtown because it's not going to happen. Developers are going to have a plan, et cetera. Why wouldn't you just protect it? Why wouldn't you just say?
I just said that you should.
No. So we have two separate maps that have been looked at. And the map that we submitted is not the same map that, staff has submitted.
Yeah, I didn't see it before tonight.
So I'm not sure if you've seen both maps to say, I don't believe these streets, these areas, these towns, there's not going to be a problem on them. I mean, we already know they're incredibly narrow streets. We know that the Uncle Road development is going to be coming down. We know that the developer for the Rite Aid building has already submitted his idea that he wants a 5th floor overlooking the downtown, an idea. And, we're already at 4 floors and now he's asking for a 5th floor because it'd be great to see the water in the downtown. Mm-hmm. And the setbacks have changed and the floor area ratio has changed. So if we already know that's coming down the pike, several developments on Sherman Street are coming down the pike. And then we have, not to mention everything else being developed. It's really, really important that you support the downtown having as much protection as possible, or we will lose the small buildings. If you can take a building down, if you could take an Archie Moore's down today, that could not be rebuilt, but soon, without having to show a parking plan, it could be built 52 feet and have maybe or maybe not have, if the 3 state reps get their way, maybe not have to have commercial.
That's not what we're talking
on
about
the ground
tonight.
floor. But I'm saying, but that building in the future, if we don't protect it, that building could come down and could be built 52 feet using the same exact footprint or larger. And if we don't protect the parking in that area, that affects all the local businesses.
Let me be clear. I think the Economic Development Commission said that we support the enactment of conservation park. So I think this is the third bit of a public hearing.
Are you in support of the area on the post road and in and around the post road to be included as
Just
part
said I
of the
was.
conservation?
Southport downtown, I don't have your specific, I'll leave that to the discretion of this board in terms of what particular areas. But again, if you think that's the area that is most in need, move forward.
If I could, Mr. Chair, through you. Staff created a map at the direction of the commission as a starting point, not as an end point. So you need to have a conversation with the rest of your commissioners amongst yourselves to decide where you want to do this, if you want to do this. Staff is not making this choice for you. We're here to help you with the tools that we have available. We're not making this choice. I just want to point that out.
And I have one more question for Mr. Markhart, and thank you so much for coming today. So a lot of these lots are owned by businesses. When you drive through Darien, you drive through Westport, you drive through parts of Fairfield, et cetera, the lot, it will say for customers only, right? For patrons of that only. So when we see maps like this, let's say we have, I think you said it was 2,947 spots using, a great percentage in terms of our land area, they're owned. People own them. So they're not necessarily going to they don't allow train station parking in them. They don't allow.
Reason.
Yeah. And so to that end, we can show this map saying that a lot of people own land downtown, but it's not land to be used by everyone.
But as you pointed out, there are tools and strategies to manage parking, right? And you have certain tools within your repertoire. And you started to talk about that in terms of ways in which we can incentivize folks to share parking so that we don't have empty lots. They're being utilized. I will say that probably many folks here listening online that have gone downtown have probably parked in a private lot and then gone across the street to do business someplace else and circled back. That should be encouraged. We don't want people to get in their car and then drive across the street because they visited the Fairfield University store and they want to go pick up a pizza at Colony, right? So they want to be able to walk across the street. We want them to keep their car there. So I think there are ways in which we can look at that. Totally separate issue. I agree that parking study shouldn't be confused with what you're considering tonight. I just think it's a good idea. Obviously, you do as well, because you put it in your plan of conservation and development, something we've talked about. There seems to be funding to do that. We'll probably need some local contributions. The Economic Development Commission is willing to step up and help fund that. We hope others will join in that effort.
Thank you. Other questions for Mr. Barnhart?
One other question. How many off-street parking spaces are there downtown? On the post road on the side
Yeah,
street?
that's included in the count, but I will ask them to try to
Number
carve
of
that out.
off-street parking.
Off-street, exactly.
Yeah, yeah.
They've apparently digitized.
I meant not
Every-
lots, just like on the roadways, on side streets.
On street.
On street.
On street, sorry,
So
on street.
this includes I believe I can see little areas that are included. I don't know. I think, again, this is conservative. So I believe it's an undercount, but there are certainly included in that number that I provided is
Yeah.
both on-street and off-street parking.
So we don't
No,
have
I
a
think-
number, right? But
I
just-
don't have the break. I didn't ask them for that breakdown.
Okay.
Part of it is, we do a parking study. I hope we do. Because I think we should look for other tools to manage parking, right? Part of it will be to confirm the information we have and then figure out what we can do to better leverage this asset. The assets we have, assets that are privately owned, that we can help encourage people to use that more efficiently. And, maybe there are opportunities to augment parking somewhere here or there. I don't know, but, I think we've got a lot to work with to begin with. I think for now, again, I don't want to, we spent a lot of time talking about a lot of other issues, but again, the purpose of tonight is whether to establish these conservation mitigation districts. And I think, we should get back to that.
Commissioner Braun?
Yeah, what's the time frame for the parking study? It hasn't been ordered yet, right? That requires some agreement on who's gonna pay for
Yeah,
it
it
and
was
what.
it was just a recommendation. Hopefully you agree. I think you do, because it was in the POCD. We would need to identify funding. I believe there is some grant funding available. So the next step would be to kind of put that together. Again, groups that would be involved in that planning effort. I think this commission should be involved, clearly. So we hope that you will.
And what's the time frame for a study like that? Usually, once it gets, you have to get funding first, then you have to, I assume, if it's town money, the RTM or Board of Finance would have to approve it.
Let's figure a year.
Okay,
Again, it doesn't, nothing here, nothing with the parking study precludes you from acting on what's before you tonight.
I appreciate that. And would it be possible to indicate either on that map that you're showing or somehow how many of those parking lots are private versus public? Because I think that makes a difference, because you can only incentivize people to share parking. You can't make them, there's all kinds of issues with
Oh, I
You know,
agree.
liability, for example, things like that.
I agree. Yeah, for sure.
Is it
We would-
possible to delineate
yes.
that, like different colors maybe or something, private versus public?
Again, I don't know that you need to spend a lot of time on that, because again, you're focused on whether or not to establish these conservation mitigation districts. So I don't want to, the Economic Development Commission did recommend a parking study. I know it's something you've talked about.
Yeah,
We
and I
do have
appreciate
some
that.
baseline
Yeah.
information, but it doesn't mean that you can't move forward and consider the establishment of a conservation mitigation district in the near term.
And has there been discussion of creating a parking garage?
Recently,
Yeah, because that's another concern. That would be
I
a
mean-
town expense. The town would be subsidizing private
not
development,
necessarily.
no, yeah.
No, I think there's a lot of different ways you could potentially finance a parking structure if you felt it appropriate, but I don't know, other than people have suggested that many, many years. And I look at, the train station, and you can see, part of the reason we have the Fairfield Blackrock station is because at one time the town decided it didn't want to put a parking structure there, and we have a Fairfield Blackrock station as a result. But I think we have a big parking field. It's not easy necessarily to navigate, get from one side of the tracks to the other. Part of those could be accessibility improvements independent from parking structure. But again, these are all things that I've talked about, but there's no plans for that, any of that. But as to how it could potentially be funded, it could be funded different ways, many different ways. It wouldn't have to be necessarily public dollars.
Other questions for Mr. Barnhart?
One last question. You might not have this answer, but do you know how many people park in the train station parking lot that are coming from like the loft or other developments where there's not enough parking? I know 15 Uncle Road, when they came before us, they conceded that they would have overflow parking on the streets, and they were trying to find, public parking lots that they could go to.
Well, they can't park at the train station without a permit during Monday through Friday during commuting hours. You know, it's free parking at all state train station parking lots on nights and weekends, which is helpful for our downtown.
Mr. Chair, if I could just add to that, I was recently able to have a conversation with our parking department staff that are situated at the police department. And, you know, they did indicate, I asked them the specific question, like how many of the apartment buildings at one time, both Fairfield U students were able to lease spaces at the Mill Plain lot. And there were also some residents in the lofts at Umpqua Place that were renting spaces, train spaces at the Mill Plain lot as well. They're not renting any spaces anymore. They've given up those spaces. So that building is able to, you know, manage the parking through the parking that they supply on site. And, you know, however else they've chosen to, you know, whether they park in the evening at the train station and they don't park during the, you know, they don't feel the need to store a car during the day is what they've told me. Because they haven't asked for a parking permit during daytime hours.
So, to that end, the lofts, anyone who commutes to New York knows the best spots on and off the train are the ones right in front of the, you know, right outside of Naughty Dolphin on one side and outside of the house, I'll call it, on the other. All those to the right-hand side of Naughty Dolphin are people who stay in the lofts at night and park their cars there and leave in the morning at around 8 o'clock. And the commuters leave, people commuting into New York are at 6:45 getting on the train, 7 o'clock, 7:30. So the best spots don't become available until a certain time. So that is important. They may not be paying for it, but they're using it.
Well, that sounds like an enforcement issue more than anything, but
It's
leave
not
that to
done.
the appropriate authorities. I will also note that, you know, businesses do sometimes need supplemental parking and will pay either private lot. I know the lot, the Cintos own behind 140 Sherman Street sometimes accommodates, you know, for example, some business has food trucks. They're difficult to park on street and they don't have parking necessarily attached to their business. They want to provide for that. So, you know, we do get those requests periodically where we need a food truck or a business service vehicle. A number of other businesses have types of equipment like that where they're looking for supplemental parking. So my point is, you know, parking is something that is of concern. I don't know that that's going to ever change because that's been the case since as long as I've been here. So I presume we'll probably be talking about parking long after I'm gone. So, but I think we could do something to try to make it a little better by looking at our existing inventory and figuring out what we can do to make it better.
One last note. Do you believe that if we do not pass these parking regulations, that we're going to lose any of our small businesses downtown? Because those buildings can then be developed to 52 feet, showing no parking plan and how important having a parking plan is to rebuilding a building.
I think there are always risks to businesses, but I don't think that's top of mind or high up on the list of risks to businesses. I mean, new regulations do require ground floor commercial, so
That's why I
presumably-
mentioned that's why I mentioned the bill that was recently voted on May 1st of this year that passed the House but hasn't passed the Senate and very likely will be reinstated.
not everything can be easily converted. We oppose anything and we've maintained that. Even we had an 830G application that you know of that has on Post Road that has ground floor residential use. I understand the commission felt it needed to because it was a set aside application under 830G, and I know your regulations allow for potentially that be converted back to ground floor commercial, but I think that's absolutely critical to maintain ground floor commercial within your commercial corridors. So we're very much opposed to any movement to put ground floor residential along commercial corridors like that.
Let's talk to the state reps.
All right, anything else from anyone who hasn't asked a question? Okay. Thank you, Mr. Barnhart.
Thank you.
Appreciate it.
And thank you for the signatures. I'll give my reserve back to you for next
Give them
time.
back to you tomorrow.
Commissioners Braun and Monahan. Oh,
Yeah, I was gonna make a suggestion.
but 1 second. Let,
Okay, sure.
Can I ask you a question? May I ask? So we keep hearing about this 52-foot limit. What was the prior to the 52-foot, what was the prior height limit?
In the Center Design District, it was 5 stories, 50 feet in height.
And
So
is
what the commission did is they eliminated 1 story and added 2 feet of additional height. So instead of 5 stories, 50 feet in height, we went to 4 stories, 52 feet in height.
So just to clarify, for many years prior to the change of 52 feet, 4 stories, the height limit was 50 feet, 5 stories.
Correct.
So we have actually less space above by the number of stories, a ground floor commercial, than we used to.
Correct.
Okay, thank you. I just wanted to clarify that.
all right, go ahead, Commissioner Braun.
There's a reason why we don't have a lot of tall buildings, putting aside 830G, and that is because of both parking and floor area ratio, and perhaps also the residential, all of which we've modified in our most recent regulations. So we probably would have seen more of those if we didn't have those other regulations. So I believe we will see more of those coming up with the combination of the state law as well as our regulations that we just passed. Because I used to ask that when Mr. Went was here, why don't we have more if that's what is allowed? The floor area ratio was lower and the parking was there required. And we've changed all that. So that's one reason why we don't have those buildings now, but we will. And yeah, I just wanted to point out another thing, and I think I think the public policy behind these parking mitigation districts is that the legislature knew there would be a need. And that's the public policy. There is a need. You can't predict what a developer will do. You don't know what the motives are or how good they're going to be or how bad they're going to be. We have parking requirements for a reason. And that's why the state legislature, even when they passed what I consider a pretty onerous bill, they allowed this little bit of wiggle room, and it would really behoove us to take full advantage of it. And the only question is exactly what the footprint should be and exactly where the zones should be. And I believe this should be the high priority zone. There's another zone. It could be the whole beach area. It could be Tunx's Hill. It could be Black Rock Turnpike. I leave that up to everyone else to decide, but I would like us to do that so that we can have this effectuated by July 1st. And I was going to suggest that there are some things we need to do to provide what Commissioner Churchill requested, and to clarify and label and things like that, and make sure we have the updated map in there. We can do all that for the 9th, but I would like to have this on our agenda for the 9th so that we can really get a lot of work done. Also, I was going to suggest, I don't know how many people are here to talk tonight, but I have a number of things to go through about consistency with the POCD that I would like to put into the record, but I don't want to take up space from members of the public that might want to speak. So I was going to suggest to the chairman that we allow them to speak first, and then I could go through that after.
We can certainly go to public comment. You're suggesting, though, that we do that you come back and speak on the POCD, but hold the hearing, hold the hearing open until June 9th?
Yeah, I think we should, because it's okay. The only deadline is we want to get this done so that we're not caught unprepared, when the law becomes effective. Okay. And we can leave I'd like to get as much public input as possible. The public is very interested. This is the downtown for everybody. It's not just for one neighborhood. And the people that spoke before were prioritizing preserving parking downtown over their own neighborhoods. So everyone has a vested interest in what happens in the center of town. I grew up here. As soon as you were old enough, you went to the center. That's where you went. And to not have enough parking is significant. So I would like to allow the public to continue. I don't see any reason not to allow the public to continue talking as long as we're talking.
As long as we can go back to talk about the P O C D and the consistency with the P O C D in terms of our mitigation districts.
I mean, we can,
Mr. Chair,
Yeah, go ahead.
if I could, I mean, from the last meeting on the 26th, we also continued several projects. That also have their own statutory timelines associated with them. And applicant expectations for processing those expeditiously. So, just know that we've reserved our planning sessions to talk about planning. We have 2 meetings a month that are oriented more towards projects. So I just don't want to end up in this situation again where you don't, as a commission, talk about the areas that you may or may not want.
look, the
Let's
the
talk
public
about this.
certainly, the
Let's
public
talk
will
about
certainly
the
get, the
POCD.
public is gonna get a chance to comment, of course. The question is really, Commissioner Braun, I just want to make sure I'm clear on what you're suggesting. It sounded like you're suggesting that we, even if we get through public comment and you get through your additional P O C D comments, that we keep the public hearing open to the next meeting. Is that right?
I don't see why not. I don't see any reason why we shouldn't allow people to write to us and give
Because there's
information.
been a lot of suggestions that some of us on the commission are trying to drag this on. So I just want to make sure I'm understanding you right. So that's fine. I mean,
I want to collect as much information as we can so we're fully informed before we decide on this important matter.
I mean, we
Okay.
could move to adopt the first map tonight if
we can't.
people are in agreement
We
that
don't-
we should be protecting that
We don't
particular
hold those
area.
on the same night as we have hearings. That's long established practice. We get requests to do that. We've gotten requests to do that. We've always been consistent about that.
Well, can we understand the time frame? I know that no one thinks there's much risk of somebody putting in an application on July 2nd, I guess, or July 1st. But am I correct on the time frame that 15 days before July 1st, is that June 16th? I think it is. And that is a day that we normally have off because that's the 3rd Tuesday. Would that be, and there's 5 Tuesdays in June, which is odd, but because it's not a long month, but would the commission entertain the possibility of meeting on the 3rd Tuesday and not meeting on the 4th Tuesday and then meeting on the 5th Tuesday? We usually would have, it normally would go the 1st Tuesday, the 2nd Tuesday we meet, the 3rd Tuesday we don't, the 4th we do. So that would mean we would not meet on the 16th, but we would meet on the 23rd, but not on the 30th. But I'm wondering if we could switch that up a little bit so that we have the time to do this and not worry about that 2-week appeal period.
I don't know, we're reshuffling the whole calendar for missing, potentially going a week past July 1st.
Just
for that
add a
district,
meeting.
but go ahead.
Mr. Chair, through you, in the background, what we do in the office is we work with applicants who submit applications to us and then have an expectation to be on our set calendar that we establish in December with the town clerk. So we already have applications scheduled for the 23rd and applicants who have worked with their consultant teams to ensure that they can all be present for those dates. So it's not as easy to just move around items on an agenda based on what's happening in the background for the office. It's the same with the Zoning Board of Appeals. When they're doing their scheduling based on applications that come in, those statutory timelines in which we are required to process them, and then getting them scheduled in a timely manner to meet those statutes on dates that are established in December. So it's not as easy for us to move around the dates without then consulting with all of those applicants, their consultant teams, and having them reshuffle their priorities based on a change of date.
I don't think this is on the next planning agenda. This is not on the next agenda, correct? This particular topic. So if not, we should get through it tonight. We should get through as much of it tonight as possible. we should talk about the P O C D, we should get,
What was it? And then
feedback.
have a vote, you're saying?
We should get feedback, and then we should keep it open if we still haven't, we haven't gotten to the end of it. Because we've been trying to discuss this topic since January, I believe it was like.
We're not going to relitigate how this
I'm not
commission has
litigating.
not tried to delay anything. Clearly, we're giving plenty of opportunity and deferring to Commissioners Braun and Monahan on whether you want to keep this open or not.
Yes, we should keep it open.
Good.
I would just like to say again, I think it's important that we hear from this room of lovely people who have once again spent a considerable amount of time with us. So I would recommend that we table the POCD conversation.
I think that was the suggestion anyway. That was to have that after.
It's a really, really important part of this
We don't need to
conversation.
argue about it because Commissioner Braun, who I believe was going to speak on it, has already offered to defer that until after public comment. Not everything has to be an argument. All right, I would.
I think we all agree. I think we all agree.
Thank you. Okay, so we will open up public comment. Again, we'll start with folks. Yes.
I'm so sorry. We've had folks in the public want to speak on the architectural standards as well. And if we don't think we're going to get to that, I would like to let those people go if we think we're going to continue those items because we're at 9 o'clock and we only have 1 hour left of our.
So I think after this, if we do get through public comment and the POCD comments, to the next item on the agenda is Commerce Drive. You're saying the other folks who are in the room are here specifically standards.
Yes, that's correct.
Okay. Is anyone opposed if we get through this? I'm not sure we will. But taking item number 4 out of order, item number 3 and 5 actually go together. Correct?
It's actually item number 4 and
Oh,
5 and 6 go
I'm
together.
sorry, I forgot.
Sorry.
I don't see a.
Yeah, my agenda. is-
Item
is
4 and
fine.
5 go together and item 3 can be moved to the end if
That's right. Okay.
if that works for the commission.
Any objections to moving 3 to the end again, if we get through this current item?
Do we need Jeff here to do didn't he work on the architectural standards? I mean, Commissioner Randolph?
You were going, I'm sorry, Director
He was
Harrigan.
I thought he was presenting that, no?
Yeah, I mean, I think Commissioner Randolph was fine with letting it proceed.
I'm sure he has input, but not his
Yeah.
document. Okay, let's open up public comment. Again, if you're joining, we will take, if we get through this, we'll take items 4 and 5 out of order. If you are joining remotely and wish to be heard, please make sure you're signed in chat and indicate you wish to speak. Anyone who's in the room, please come on up, state your name, address, and keep your comments germane to the issue. 3 minutes. First come, first serve. So one up after.
3 minutes.
Good evening.
All right, my name is Matthew Halleck. I live here in Fairfield on Somerville Street. I'm also the owner and publisher of a newspaper, newsletter, somewhat influential. Just a couple quick points. Forget the parking. Why don't we just, when I was in Hawaii, there's 2 great things that Hawaii does. Everybody has open access to the water. So you could be at a 5-star resort and any surfer, anybody can go to the water. And they have underground parking. All right. I know, you talk to developers, they make it sound like it's a lunar landing. It's not that hard. All right. It's a hole in the ground. It costs them money, but have some underground parking, right? Like in Manhattan. The other thing is regarding Commissioner Braun, there is nobody that is more articulate. There is nobody that is a greater gladiator. There's nobody that has spent more uncompensated hours of her own time on behalf of Fairfield than her. And I just always have ultimate respect for anything that she does. And I hear her talking tonight. And if she is stressed out or is not satisfied, then in my opinion, the public is stressed out and not satisfied. And I just would like all times to have total deference to her. And especially she's the secretary of the commission. Okay. The one thing I want to talk about real quick is we're going to be signing, I don't know if you've heard of the Connecticut ERA, Equal Rights Amendment Award. 35 organizations throughout the state sent a long letter to Commissioner Tong around Earth Day, Earth Month, about the right to health for everybody here. I think the best analogy I can give is when they had secondhand smoke. And it was like our right in restaurants to breathe clean air is greater than your right to smoke. And that's basically the basis of this entire movement. It's like our right for a clean environment is far greater, exceeds than any developer's right. And it's going to be upsetting a lot of plans coming forward. And so just speaking on behalf of the public, we are going to be getting behind it and want Fairfield to be a part of that. So regarding the park, before I run out of time, regarding the parking, we have some major problems with the plan and with the POCD that have to really be addressed. I've talked about it before. The flood zone maps are dangerously wrong. All right, all of that downtown there is in a flood zone. They've removed one of the best maps that Fairfield ever did in 1979 town plan, published in 1980. There was a comprehensive map that they removed from the town plan that shows, if anything, the second downtown of Fairfield is Tunxus. All right, that was just removed from the map. They removed Black Rock Harbor. It was all around District 6 and Commerce Drive and that whole development down there. So we really, really have to address that because there's major liabilities and there's mistakes, and we cannot be responsible as a town to move forward with those mistakes in the plan. In addition to other things in the plan, I've gone through the whole thing in detail. We have over 250 comments. It really has very, very limited value. There's major, major sections from sustainable energy to parking to the environment that are not even covered at all. The education section is 1 page long, looks like a Wikipedia entry. It's ridiculous. So all of that has to be examined. And I looked in the charter, and the commission has every right to accept any input and any consult, any reports, anything at any given time. And we have every right to update the charter, even though the plan, even though it's already been approved, we can update it. We can put more things in there. It's not really due until November anyway. So there's no problem with us updating the plan and putting correct information in there. And speaking of the charter, real quick before I go, regarding the town attorney, we do not have a town attorney on staff. We have outside consult that we hire as a 1099. According to the charter, we're supposed to have two attorneys on staff as part of our legal department. We do not staff it. And that's a major dynamic because instead of having the attorney tell us that he can't tell us what's going on and meeting people with private executive sessions, we would have our own on-staff attorneys, and we would not be having this problem. So I don't understand why we don't fulfill what's in the charter and have on-staff attorneys. Thank you.
One up if you'd like to speak.
Jackson Shostak at 138 Figler Avenue. I highly encourage the commission to adopt this first district. I think Commissioner Braun and Commissioner Moynihan did a great job at addressing the parking issues and concerns downtown. Obviously with the commercial conversions that could be occurring in the next couple of months or applied for at least, we have to make sure that our local small businesses are protected and that people from across town, no matter their locality to downtown, can access and find parking available to them. So I encourage adoption eventually down the line, but I also encourage the commission to make use of that other 4%, I'm pretty sure, that other district as well before time runs out. I would encourage maybe looking at Black Rock Turnpike. There's lots of commercial property there that I'm sure developers could be eyeing, or Stratfield Road or Tunxus Hill. So thank you. Thank you.
Nancy Haberly, Duck Farm Road, Fairfield. I agree with the encouraging you to adopt that.
Speak a little bit.
I'm sorry.
Yeah.
to adopt the parking zoning commission. And I think until both parties are willing to put aside politics and listen to the voters, we're not going to be doing what's right for Fairfield. We're going in a direction that doesn't work for the town residents. Thinking that you know what's best with complete disregard to the people who live here, whether they voted for you or not, is what's causing the problems we're seeing here tonight. A lack of transparency leads to a lack of trust in your proceedings and the eventual outcome. You're too busy doing the bidding of a party and the state over our town. And I'm really disillusioned by the administration and our elected officials. You know, we have to stop the insanity and do what's right for the voters and the taxpayers. And it's not parking nonsense that you're supporting tonight or claiming it's not going to be affected. Like people are saying, these buildings are going to go up and developers are going to do what they're going to do. You can't trust them. I'm sorry. And Mark even said, they're all about money. Yeah, they're all about money. They just want to make money. Ridiculous. The process is broken, which has allowed this issue to be kicked down the road and hoping that time runs out. And though I'm hearing now time didn't run out, that this has all been approved already in March. So I'm very confused now too. But it's a mess. You know, we see you. We've known about this by the documents dating back, and it's obvious that the board is taking marching orders from town hall. It's going to pose many challenges for town small businesses. And next up is parking meters. So we're going to have all these lots that Mark showed us. And those are private lots. I understand there's a lot of mixture happening here. There's mixed lots, you know, for certain areas. But so now I'm going to come to town for dinner and I'm going to have to either pay a meter. It's coming. Like, we're not stupid. I'm sorry. We're not idiots. It's coming. You're going to tell us we have to pay for this lot because you're telling me a developer who owns a lot and owns land is not going to start charging people to come to park in town. Please. I mean, I wasn't born yesterday. You know, and and when people email you, you need to respond to them. I emailed about that flagpole at Porsche. Haven't heard one word. You're telling me I know it's not on topic, but that is not in line with this town. That is not in line with a historic town. That flagpole and that flag is bigger than this room. It is despicable. It is an offense to my eyes every time. I couldn't believe my eyes. Anyway, wake up. You are not doing what the town wants.
The size of the flag or the
Everything.
flag?
The flagpole is monster. It's like what was in Stanford from the
I didn't get that
WWE.
letter, so yeah.
It is atrocious. It is disgusting. It is not what Fairfield should represent. It is appalling to me.
Ma'am, where did you email? Where did you email?
I emailed your commission.
No, we didn't get one. Did you send it to the first select
No,
person?
I sent it to the TPZ commission through the website to all.
When did you send it? You remember?
Thursday, I drove through and saw it with my daughter.
And that's when you sent it? Was on Thursday? I'll check and see if, for whatever reason, it got sent into a different box. I'll double check for you.
I have it, you mean, I have it in my, my drafts here. I copied it and pasted it here. Because once you send it, you lose it.
Yeah, I did not see that or receive it. Did you see it?
I have, I mean,
Okay.
I can pull it up if you want somebody else to speak. I can pull it up and I'll read it. I mean, it's, anyway, it's appalling to me.
And if you could call the office tomorrow.
It's like, who's signing off on that? Who is signing off on that? That is horrifying.
You have the phone number for the office? Director Harrigan would like you to call the office tomorrow. Do you have the phone number?
I guess, I'm sure. Do you mean call town hall?
Yeah, it's on the website. So if you want to call TPZ tomorrow, I didn't see anything referring that,
Okay,
so.
well, I can copy it and maybe resend it to a TPZ. Because I went through the form, filled my name in the boxes.
Okay. I'll double check that.
I have a question about emails. Do people have to put down a matter on the agenda for it to come to us, or can any topic just get to us?
Generally, if something comes There are two ways to reach the TPZ Commission. One is the TPZ Commission at fairfieldct.org or .gov. And the other way is there is a contact TPZ department form that you fill out,
That's what I did.
and then that gets forwarded to our staff.
That's what I did.
So I will double check that tomorrow.
I would love to get those emails directly from the public instead of having it.
Go ahead, Ben.
Okay, hi, thanks, everybody. I'm Vicky Ilfeld. I'm on Hollydale Road. I'm also a realtor in town. I have been for about 16 years or so. And I have come to the last few of these on Tuesday night, especially on this topic about the parking mitigation zones that are up for discussion. And I have yet to hear from anyone that thinks it's a terrible idea. If you go through all of the public comment that's posted online as well, there may be one or two letters against it. And now tonight we were able to thankfully hear from the Director of Economic Development, and he is also saying that there's no downside to it. So I don't know why we would not do it at this point. It's almost like it brings to mind the quote, "Hope is not a strategy." We're hoping that a developer doesn't come in and do that. And it seems like they wouldn't, because to have a marketable product, they would supply parking. But that's hoping. We're hoping that. Let's put this in place. I think that the town has spoken. Everyone that has come here has spoken in favor of it. This is a very important corridor to the residents, to people moving to Fairfield, to people selling their homes in Fairfield, that this quaint downtown exists. It's a great selling feature for, our clients selling and buying. So protecting it. And the map, I think, is great. I think that's exactly how I would sort of look to lay it out as well. And so thank you. I hope you vote to protect downtown.
Thank you.
Thank you.
Good evening. My name is Linda Devaney. I live at 163 Maylands Road in Fairfield, up by Fairfield U. I did speak once before at one of these meetings. Again, there was a few more things brought up tonight, and on this topic of the parking zones for downtown. It is so important. I mean, I'm sure you all realize this. You all live here. You all, I'm sure, go to the restaurants, go to the Fairfield Theater for events. How many times have you gone there and not been able to park your car? And there are new restaurants coming in. There's a new restaurant going in, a Greek restaurant next door to Archie Moore's. That spot has been empty for at least a year, maybe longer, since Crave or whatever was there before left. That's going to bring how many more people looking for parking in that same area? When there's a concert or a show at that theater, there's a limited amount of places. And you would think with that enormous amount of parking for the train station, that would be enough, but surprisingly it isn't. And also, we also have to think not everybody can walk 4 blocks, 5 blocks, 6 blocks, or wherever to go park by the Recplex or to go park in the structure behind the Fairfield bookstore. Some people have disabilities. Some people have limitations. My husband being one of them. He can only walk about a block, and after that, he's going to need to sit down and rest. So it's very important when we go out downtown that we can find, usually we do okay within a block. You can, maybe drive around the block 5 or 6 times, but eventually you'll find something within a block. But if we start allowing development in the downtown, residential development, and we don't force the developers to provide parking, and there are, one building that's got, 25 cars, and another building that's got 12 cars, and another building that's got 8 cars, all these cars have to park somewhere. And they have to park during the day when these people are at work. They have to park at night when these people are sleeping, and they're taking up spaces. They're going to take up spaces on the street, spaces in any of the public parking areas, and there will be less parking available to the residents who don't live downtown, who want to come down and shop, who want to come down and go to Old Post Tavern, who want to come down and mail something at FedEx or whatever they're doing, go to 16 Handles for yogurt, whatever. There will be less places for those people to come and park and take advantage and support our retail establishments. And once we start to lose the retail establishments, what happens to the town? It's not a good thing. So, and you also cannot depend on developers. Developers are weasels. I think we all know that. Sorry if any of you were here, but there's a lot of weasel activity going on, and we know that. And it's a profit-based business. Everybody wants to make money. We all go to work to make money. We all want to have profit, extra money, excess of, the ability to do things. It makes sense. But that's why you have to have rules. And that's why this commission has got to vote to approve these conservation parking areas. This one district sounds great where the map was, downtown Fairfield. I would suggest perhaps the next one could be in the beach area. Someone else mentioned over Black Rock Turnpike area, but that has to be looked at too. We have to get to the second district and make sure we preserve as much parking as we can within the framework of what Hartford has allowed, since they have dropped their heavy hand and told us what we can do. So again, I would urge the commission to please approve when you do eventually vote, whenever that's going to be. I don't know. It's getting pushed off again. Well, whenever you eventually have your vote, please approve these parking districts. Please set up the second district, and let's all hope we have a vibrant downtown and plenty of parking. Thank you.
Thank you, Linda.
Anyone else wish to speak?
Good evening. My name is Susan DiCarlo. I live at 264 Crestwood Road. Thank you to the commission for opening this up for public comment and putting it on the agenda tonight. I, along with several other people in the room or who've been here earlier tonight, this is, I think, several meetings that we've attended because we specifically feel this is a very important issue for our town. I'd like to also thank Commissioner Braun and Monahan for taking the time to put together such a thoughtful plan. I'd like to say I support it, and I hope the commission moves ahead and adopts what they've presented so far, in addition to identifying another area that meets the 4% requirement. Just a couple of thoughts I had when Mark Barnhart was speaking that I'd like to share with you is he had mentioned a couple of additional lots that seem to have extra capacity or presently underutilized. One being the Recplex and the other being the lot across the street, which is the overflow for the train station. And the one thought that came to mind was, okay, yes, I do drive by those lots. What if I wanted to go to Starbucks because that parking is challenging, or I wanted to go to Pop-Up Bagels, which is just around the corner on Post Road from Mill Plain Road. That parking is challenging. And I'm like, would any of us seriously use those lots? Because that one stretch of road underneath the train overpass is so narrow. There's no sidewalks. I don't think that's realistic to think you can just say there's available capacity and those businesses are within walking distance. That's obviously, to me, a safety issue. Unfortunately, available parking isn't necessarily accessible to downtown merchants or stores that are lacking the parking or need additional parking. The other thing I wanted to bring to your attention is both yesterday and today, I traveled the Post Road at 11 a.m. and 2 p.m. And what I found was it was backlogged from traffic light to traffic light. So well over a block. And that stretch went from Sasko Hill Road all the way to Round Hill Road. And it was because of construction on I-95. And so how does that impact parking? Well, when you're trying to do on-street parking or turn into a parking lot or a business, and you have car after car after car lined up and the traffic light doesn't allow that traffic to move very quickly or flow, or cars back up the intersection, it just makes it, again, another challenging obstacle to navigate, especially if there's on-street parking. So I think you can look at the numbers of how much parking we require and how much is available, but there's other considerations. So in conclusion, I'd like to encourage the commission to accept this recommendation, not only just for public safety, but also doing, what we need to do as a town and a community to support our local merchants, and also to, in general, to provide some guidelines and guardrails that will help the residents of this town just have enjoyment of our local town center and town itself. So that's all I have to say. Thank you.
Hi, I've spoken twice before, Bridget McNamara, Carroll Road. Just want to say that I think it's important that we get at least this first parking area buckled up in a timely manner, like in the next couple weeks. The idea that Braun and Monahan have proposed, I think, is ideal. I think everyone here has spoken to the same thing. I agree with everything that everyone prior to me has said. And I believe that all of us represent a very large cross-section of the majority of the members of our town who feel, like everyone else has said, that is the important part of our town, from wherever it starts, Circle, all the way to Southport. I think the idea of having a minimum of 18 people living in a house with no parking, having them all over the street, I just think is an asinine idea that would really destroy, tie up, really ruin downtown. So again, please, right away before July 1st, approve the map that Ms. Monahan and Ms. Braun have put together. And let's get on this, and let's stop stalling and, waiting for the impending doom that you say is not going to happen, but I'm pretty sure there's a lineup of people waiting to do this to our town.
Good evening. I'm Emily Howe. I live on Elm Street. I'm here in support, obviously, of the conservation and traffic mitigation districts. I want to acknowledge how much progress was made this evening. And I know it's been like a really long night and people are probably feeling a little upset, but like really, we've made huge progress. I love the way that the zone has been conceived to cover two of the three historic districts that the POCD calls out for cultural preservation. I think that it's great that of the 5 areas that were of highest priority noted by townspeople in the letter submitted to the public record, that they were 3 of the 5 have been covered by this map, which suggests to me that a second zone could cover the 5 top priorities of the townspeople, and that's kind of thrilling. I would note that who downtown parking is actually for. Demand isn't generated mainly by the people who will live in new sub 16 unit buildings. It's generated by residents who drive to downtown from elsewhere in Fairfield and other places to shop, eat, conduct business. The Fairfield train station has surface lots for over 1,000 commuters because people drive to transit to leave Fairfield for work in Stamford and New York. They don't take the train into Fairfield. The parking reform literature assumes urban contexts where users arrive without a car, and Fairfield isn't one of those contexts. So, removing parking minimums for new development reduces supply for the overwhelming majority of downtown users who arrive by car. And I love that this one tool, the CPMD, preserves that supply, and particularly during this gap period of time. I very much appreciated that Mark Barnhart was able to come today and was, you know, a calm and rational person, largely. And I think that the public should inform the answer here. I don't see any harm in adopting this zone today. It's possible to change it in the future, so it's not like it needs to be set in stone. I really appreciate you all being part of this commission, truly, because I think it's such a valuable service to Fairfield and for all of us keyboard warriors out there who care so much about Fairfield. I do recognize that you care about Fairfield too. Thank you.
Anyone else in the room who wishes to speak? Mr. Mullen, is there anyone online who wants to speak?
We do not have anyone signed in the chat, Mr. Chairman.
And if you're joining us remotely and want to be heard on this item, please indicate in chat that you want to speak. That looks like. So I'll close public comment. Commissioner Braun, can you just give me a rough estimate of how long you need to run through the POCD piece?
Yeah, I'll run through it quickly, and I think what I might do, because I would really like for us to talk a little bit about this and see if there's a consensus on this first zone before we leave tonight, in light of, you know, the time frame. So what I think what I'll do is I'll run through the high points and then I'll put it in writing and submit it so it's got more detail. Because I know Commissioner Randolph had said that what we put forth was not consistent with the POCD, and I just wanted to address that. I thought that was important. So the POCD basically has commercial corridors, and this is one of the commercial corridors where density is being concentrated. And this allowance under the housing law allows us to be flexible on how we're going to manage the traffic and parking impacts as density comes in. We know density will come in one way or the other. There will be more density based on our zoning regulations, which are guided by the POCD, which you all know I voted against. I thought it was way too much, but it's in there. And so there will be density. So this, you know, the housing law allows us to do this, and it would support those density visions of the POCD by allowing us to have the flexibility of requiring parking so it doesn't become a burden on our businesses. And there's other goals. Quality residential areas that include historic districts will continue to predominate. That's a goal of the POCD. High quality commercial areas will be visually attractive and support additional vibrant economic activity. Another goal of the POCD, multimodal streets are a priority. So residents will have safe and convenient spaces where they can walk and bike. These are all consistent with developing adequate parking in the downtown areas for all of those purposes. In the safety section, it's the POCD points out that the post road around the downtown is home to a large number of crashes, especially pedestrian involved crashes. It's home to the town, some of the town's most walkable businesses, and obviously preserving parking will help with that. If you have too much overflow parking, it affects sightline. We actually turned down the 15 Uncle Road initially because of sightline, because of parked cars that never leave Sanford Street. Unfortunately, the judge didn't agree with us, but he didn't agree we should have done that. But we concluded that, and our town engineer concluded, cars parked along Sanford Street would affect sightline of people leaving that massive development on 15 Uncle Road. That was a valid consideration. The judge didn't agree legally, but he didn't challenge the fact that that affects sightline. Exit 24, the exit off I-95 that intersects with Route 1 is the location of a considerable number of crashes. And we do have crash data, which, and I think we can, by the next meeting, we can massage it better so it's labeled better so people can identify what we've submitted versus what's already, you know, in the record, what's new. And just to clarify it, as Commissioner Churchill suggested, In the parking section, the POCD points out that the downtown station has the strongest walkable character in Fairfield with, shopping, dining, community uses, schools, workplaces, all located in the area. Same level of train service as Black Rock Station, and on-street parking is regulated, yet the area is subject to the same parking standards as less walkable and transit accessible areas. So the POCD is basically saying that downtown deserves different parking treatment than the rest of the town. And this district is a legal mechanism that 25-1 offers to give that different treatment. And actually, when you look back at our transit-oriented development study from 2019, that kind of points out the same thing, that the downtown should be a lower scale development. We want to preserve the character of the community and the ability for people to walk. So basically, the POCD wants us to focus on more diverse housing options in the commercial corridor and adjacent to the Fairfield downtown. This parking district covers those corridors, downtown, the Post Road spine, the historic Southport Village. The POCD safety findings at the Post Road around downtown and exit 24, they sort of corroborate with the Connecticut DOT and Yukon crash data. Mentioned as traffic mitigation rationale required by Section 19. The POCD's goal of quality residential areas that include historic districts will continue to be the predominant land use. This supports including the historic Southport Village portion of that. So Connecticut General Statutes 8-2, a zoning regulation amendment has to be made in accordance with the comprehensive plan, shall be designed to achieve all the listed purposes, which include in the statute, lessen congestion in the streets, facilitate the adequate provision of transportation. And that is those are reasons, again, why we must adopt this in the downtown area. So there is a parking reform language section of the POCD. So, to sort of reduce the amount of unneeded lots, but it basically says where possible. And it's not possible in every place to eliminate parking. So what we're saying is, this is where we need it. This is where the businesses need it. This is where public safety needs it. This is where everyone in town wants it. Almost nobody has gone against this. Even Mr. Barnhart has said, he said,
There's no downside.
there's more supporting it than against it. So there's more reason to do this here than there is not to do it here. So what I'm going to do, not to belabor this, I'm going to submit this, a clarified version of what I just sort of read to you. So you have it, so you can see that it is consistent with the POCD. And I would really, I would offer Commissioner Monahan any further comments, but I'm hoping that our commission can have a few comments and see if we can have a consensus tonight, because the time is getting short.
So first of all, Commissioner Monahan, if you want to add
Yeah.
anything, there's one person joining remotely
Sure,
who
yeah.
can't type fast enough and does want to speak. So I also want to get to them.
Okay.
And then I would like to close
Mhm.
this tonight so we can put it on the calendar for a vote, but also open the next item quickly before we have to adjourn. Is the person ready to go?
I just asked them down to unmute. Celeste Davis.
Davis.
Good evening. My name is Celeste Davis. I live on Finn Street in Fairfield. And first of all, I want to say thank you for giving up your Tuesdays and coming. I know that it's not easy. I agreed with everyone that spoke. I think that we need to protect parking all over town. I agree with the map that Commissioner Braun and Monahan created. I think that we definitely need that second map, and whether it's the Tunxus Hill area or the Black Rock Turnpike area, but we need to protect parking throughout the town of Fairfield. Earlier in the evening, Commissioner Monahan brought up Beach Road, which is a development that went through a lot of legal litigation. They're now renting the spaces there, and cars are parking on the street, and they are parking at the First Church. First Church has had to install signs protecting their parking. This is going to happen all over town if we do not do something about this. Who is enforcing and making sure that these developers are not letting their tenants park wherever they want? This is going to happen when Umpqua Road is developed. We need to take care of this now. I came to many of these meetings regarding the St. Emery's development, and we were concerned about parking then. When they start building, my husband and I will be very concerned with the parking. We need to take care of this now. I think we can take care of the initial part of this evening. Thank you, Commissioner Braun and Monahan, for all of the hard work that you have done. And that's all I have to say.
Thank you.
Thank you.
Commissioner Monahan, anything to add?
I just think that the center area, you know, the districts that we selected, or the one area that we suggested so far, which is 4%, contains Fairfield's walkable downtown center and train station and the post road commercial areas from Mill River East to Kings Highway, Route 1. It includes the Old Post Historic District, the Town Hall campus with the Fairfield Museum, Library, Sherman Green. It's that entire area and Southport Harbor that are the heart and soul of Fairfield. If people believe that they're not going to be able to find a parking spot downtown, they will stop coming. And I don't believe that we are looking to future inhabitants of the town. I feel like we should be first taking care of the people in the town. And I don't believe that by not building apartment buildings over every parcel downtown, we're going to all of a sudden not grow and develop and be this, this town that people kind of want to move to. I think it's really important to note that according to the data, and again, this is weather data, which you can all Google. In 2025, there were 147 days with rain, sleet, or snow in Fairfield. So that's a lot of days for people to have to walk, a very far distance to go to a shop, a restaurant, a show, to go to the dentist's office, to go drop off packages, et cetera, and be expected to park and carry their things with them, especially as someone said, not everyone is able physically to walk a significant distance to go to places they love. So I think, in addition to us talking about, the downtown being important for all, I think it's also very important to tie in our seasonality and also the seasonality of businesses in terms of also when they make their most money.
Thank you. Okay, so we will close the public hearing to.
We had wanted to discuss what the consensus is by the commission.
If anyone wants to weigh in.
Weighing in on how they feel about this particular topic.
Anyone's welcome to weigh in if they'd like to. Commissioner Huntley.
I had a question about the 628 respondents of the survey. Was that demographically representative of the town? Who was surveyed and what questions were they asked?
Oh, I think people just shared it organically, and it just, they shared it and it all tracked back.
Just like those Facebook posts or something compiled, or?
We're sharing it on Instagram. They were sharing it on Facebook. They were sharing it on Nextdoor. They were sharing it with their family members.
So do we have the questions of the survey of what they were actually asked?
Yeah, happy to send it. We'll finish that in
here.
Sorry, can you make it what they're talking about?
Yeah, they were asked what zones they wanted to protect. That's it.
what areas.
The language matters and who we would consider a representative sample of Fairfielders would matter. So it's not quite as cut and dry as all that.
I mean, you could look at it right now. It's live. Let's see. I can tell you what it is.
Wills. Commissioner Caposa, did you have your hand up too?
Oh, no, I was.
Thank you, Commissioner Delgado.
Do you want to know what the address is? I mean,
It's on the system. That's.
You could read the questions
In the public, comment, like a link to the actual survey so that could be considered, because I believe the survey is cited in the document that was submitted with, right? Could we get a link to it when you update the links to your data? Okay, great.
Commissioner Delgado.
And I feel like if we're keeping the hearing open.
I think the request was to close it, so, and have a vote on it at the next one.
Motion track this. Ultimately, I'm not objecting to the district. I mean, I object to some of the pretenses of the conversations that we're having, but ultimately, I don't think it'll function the way that we hope it will. But if it does provide some opportunity to prevent some of these kind of like worst case scenarios, then I'm willing to support it.
So can you just expand on why you don't think it would be what you just mentioned?
I think because ultimately, what I would expect to happen here is that we're talking about larger developments. I think if I'm really going to focus on an area, it would be in places that are probably somewhere in the middle that could end up creating larger traffic issues. Than here, like most of them would end up being over 16 and end up having to do a parking analysis anyways. That aside, I'm willing to support it because I don't see the harm similar to what Director Barnhart told us. But the pretenses, as I said, are the things that I have issues with. Regardless, I don't necessarily see the harm, so.
Any other comments for this evening? Is that a hand up? Sorry, I couldn't see it from here.
Yeah, I just wanted to agree with Commissioner Delgado and say that my experience is like walking around in these types of districts and like Bridgeport, Norwalk, et cetera. And like what he was saying about the middle districts, like it tracks like it. So I just wanted to agree with like that.
Okay. So we will close the public hearing on this item. We can schedule it as a vote on the next agenda. Go from there. Thank you, everyone. And apologize that we don't have a lot of time for this last item, but we'll open it up at least. Section 17, architectural and site design standards. Zoning regulation revisions, the existing standards that apply to any property in a design business district or design industrial district with the addition of supplemental graphics.
Can we just open it up to public comment and then leave it open? Because I think.
Yeah, we're
this is
certainly
a
not going to close
broader-
it.
This is a broader conversation to have, and these folks have been waiting a long time to be.
And I'm
able to-
sorry, can I just ask, what is the intent? Do you have comments to make or something to present?
if-
I'll explain when I get there. And we can be brief. And I really appreciate the accommodation you're making.
So we'll turn it over to public comment. With the understanding that we'll keep this open.
My name is John Nupp. I'm an attorney with an office at 42 Cherry Street in Milford, Connecticut. Bear with me for a second. I'm also a resident in Fairfield since 1990. I was on this commission for many years, and I was the author of your architectural regulations in section 17.4. So we're not here to argue. We're here to be collaborative with you. And I was also the attorney who represented the Walgreens project many years ago that I'm not sure if any of you were living in Fairfield at the time. It was rather contentious. It was on the property that is the subject of my client's contract to purchase. It is the parcel that is in between the little pink house in Southport on Post Road and the Gerlich and Herb building. That's now completely vacant, a lot of rock, a lot of weeds. So about a year ago, I was engaged by my clients, Kristen and Ken Bodenstein, who are wonderful people. They operate the Goddard Nursery School in Westport and Darien. They had hired John Wicko, our architect. I know John for many years from our time in Milford together. We go back a long ways with Emmeline when she was back in Milford. And I was really excited because John has designed a really gorgeous building. And I was thinking that this is the building that will really create a great template for Southport, for Post Road. What I said to Emmeline and to others is this is going to be the best looking building, not only that portion of Post Road, maybe the entirety of Post Road. And we also have.
Excuse me, which lot is this?
So that is the vacant parcel between Gerlich and Herb.
Triangle.
the triangle, but the tip of the triangle is the pink house. We also engaged Brandon Hanfield, who's a very terrific professional engineer, has designed a beautiful site, great landscaping. We did our code review, super excited, everyone was on board. And then we heard that the regulations have changed with regard to setbacks and some, distance requirements or the frontage build out requirements. I mean, essentially what I would call form-based code. I've had a lot of experience in lots of different towns, so have adopted form-based codes, whether it's Hamden or Norwalk or Bridgeport, lots of other places. And I get the intent and I embrace the intent. And I look at the Rite Aid site and say, yeah, that building should be out to the sidewalk. So again, this is not a point of argument, but in designing this site, given the odd configuration of that parcel, we have 2 front yards. We don't have property lines that align in a parallel fashion. We have certain specific needs because this is a nursery school designed to handle young children and their parents. And so there are certain things with which it is very difficult to comply. Nonetheless, we've had a couple of very candid and robust conversations with Emmeline. She's been really generous with her time, as she always is. We had a back and forth today in terms of how we may modify. We can submit our own regulation amendment to address some of these issues. And we're not asking to be excused or waived from them. So the things that sort of concerned us at the beginning were the max setback of being 10 feet, the 70% build out, and the max curb cut or the max space between the build out area is being 24 feet. And we'll explain why it is. So, and maybe, John, can you pull up the site plan? And John and Brandon, feel free to come up and we can talk through this together. But let's show the plan as we originally designed it. And this actually may have applicability. I don't want to turn this into a charrette on our project, but I think this may have applicability on other locations, particularly where there is a lot that has 2 front yards.
And if I could also just kind of be a bit additive to this, and I know that we have perhaps somebody else who wants to speak to these. We produce our regulations with an ideal in mind. How we know whether or not we need to break and kind of reconfigure our regulations is through project submittals. And so I will say that Mr. Wicko, Mr. Attorney Nuff, and Brandon, his other consultant, they've been very gracious and kind of saying, we get it, but there are practical considerations. So that's why we also noticed our section 6, our design business district regulations, because in helping to articulate what architectural design standards we want to slightly revise, hopefully improve based on John's great initial work as a TPZ commissioner. We also have to kind of think through very specific scenarios to make sure that we're not flexing too far in one direction, that we're providing a little bit of design flexibility where needed. And I just thought that this would be a helpful example to kind of understand those proposed regulations and maybe where we need to add some flexibility in the language.
Okay, so this gives you a good sense of the layout. We'll show you the elevations because they're really special, but just a few things to call out, because obviously we make the building parallel with that side property line, the western property line, and also with the eastern one as well. We have a curb cut that helps facilitate traffic, which is actually 36 feet, not the 24 feet that you were mentioning. And it is literally impossible to have 70% build out on the 2 front yards that we have, one being Post Road and one being Kings Highway West. Now, I understand that there is in the architectural regs a provision whereby the build out area can be satisfied either with a low masonry wall or landscaping. And if that's the intent, that's terrific. That solves our problem. But you can imagine trying to develop a site like this requiring 70% build out with one 24-foot wide curb cut where it lines up perfectly with the existing traffic signal. So, John, can you show the elevations, because I've been speaking highly of them, and so I just don't want to bury the lead here.
It's further in the original application, which is the site plan file that you had.
And really what my client said to me today was what they wanted to build was a Southport cottage for kids. And that was the design intent.
Yeah, unfortunately, John, Brandon just submitted the site plan and not the full application, which has the building.
Oh, but I have oh, geez. Well, if we're gonna do this by paper and if you can send it to me, we'll upload it.
No, the actual building itself.
Yeah. We can, if you send it to me digitally, John, we can add it to this.
Oh, no, and by the way, it was in the code review thing that we sent, but I don't want to.
I don't think we got that digitally. I think it was just a paper.
Okay. Well, maybe John can spend 30 seconds just to describe the building.
Yeah, thank you.
And again, I want to be clear, this isn't for a pre-app purpose, this isn't for any of that.
No, I agree.
It's to provide an actual example where, again, right now we have very black and white language. And I just think we need to figure out where those gray areas are that we maybe could contemplate that we need to be more cognizant of.
And based on the building type, which was a preschool, it's a very residential looking, which is typical of the Goddard prototype, which is a nationally franchised, acclaimed school. So many different roof lines, many different fields of massing is in and out, up and down. So as John said, this is the post road front, which we made deliberately, and we also altered to address your parallel approach. So that worked out where it actually looks the same, but the building behind it is skewed. So there are some inconsistencies with the typical 3 to 5 story building. It's more like a cottage, as Kristen had mentioned, which is part of the prototype. So this is the building, and that's all I really need to say about it this month, just so you have an idea what we're talking about. That plan looks like this.
So then, can you show the revised plan that Brandon sent? And as John Wicker had indicated, we can create a wall that is that's no greater than 10 feet from the front yard property line. There is sort of an odd jog where the bus stop is. So we're 10 feet off of that. It is parallel to Post Road. We can do a 70% build out if that can be accomplished through landscaping or masonry wall. We think
it's in the folder.
Landscaping is better because it just creates a little bit more room, a better opportunity for landscaping than trying to take up that space with a masonry wall. And then also it solves a problem with having 2 front yards, because we never want a curb cut on Kings Highway West. The people on Kings Highway West, I promise you, I still have scars from Walgreens.
Yeah.
They don't want a curb cut. We don't want one either. We embrace your idea of light poles being a maximum of 12 feet high. We don't have to do that. We're doing that voluntarily. We want this to be charming beyond belief. We want to create an enclosure with landscaping. We want to create a place where people feel 100% comfortable bringing the most precious people in their lives. So we've been able to, I think if you can zoom in a little bit. So John's been able to, well, first of all, Brandon has slid the building closer to Post Road. We've been able to create the sort of like, I don't want to call it a false front, because it actually is, the building is parallel to Route 1. Brandon did eliminate one of the lanes onto Post Road. And so that we only have a 24-foot gap in the total frontage. And again, the balance of the frontage on Post Road and on Kings Highway West is being achieved through landscaping and through, well, we're not proposing a wall, but through landscaping. So that gets us past the hurdles of the max setback, the 70% build outs, and the curb cut max at 24 feet, which are in your new regulations. The facade parallel to Post Road, that is not in your regulations yet. That's in your architectural regs. But we want to, even though we would hope to apply before those all become effective. But so we can comply with those. I don't know whether we can comply with the transparency requirements. That's a 60% transparency requirement. You do?
Yeah, John Wicko, architect, 58 Broad Street, by the way, for the record. The portion that I skewed, the transparency, including the porch, which is an open porch, is used for the students in inclement weather. That is 60.
Okay, so we're good.
Yeah,
Okay.
it's over 60%.
Okay, so anyway, I didn't want to turn this into a charrette on our project, and we appreciate the opportunity to present this to you. But our overall point with regard to your new regulations and your draft architectural regulations is that there will be ripple effects throughout every property. As a result of the regulations you passed, there are dozens, if not hundreds, of non-conforming lots in all your commercial zones. It happens. It's happened in Norwalk, and people are dealing with it. There's lots of non-conformities, and you work your way around it. Fortunately, you have a great staff to help applicants navigate through all that. But there is going to be, I guess my point is, you're going to need some flexibility because not every site is a rectangle. Not every site is going to have frontage on one street. Not every lot is going to be a non-corner lots. And so I think it's important that you maintain that flexibility. And fortunately, you have smart people who know how to comply with the regulations as best as they can and meet the spirit of the regulations if we can't always comply with the absolute letter of the regulations. And hopefully you like this, because I really want to be back here in July with the reg change and this application. So
Can I ask Mr. Nuff a question? I mean, Attorney Nuff.
we have plenty of parking.
That wasn't what I was going to ask. So basically, you're sort of distinguishing this part of the commercial area from the rest. This is totally different and distinct from the rest of this is not downtown.
No, but the regulations apply to the center design as well as the regular commercial. So yes.
I'm really glad you showed this illustration. It's very interesting. Thank you.
Okay.
Go ahead. Commissioner Levy.
Yeah, just a couple of questions. This is the rock pile, sort of.
That's one word for it. Yeah. Guilford has one of those. You know, there's lots of rock piles around Connecticut.
I mean, the building is still more than 10 feet back, but you put the wall in, is it?
No.
What is 10 feet?
So I don't know if you can see the red notch or the orange notch. Yeah. That's the property line because there's a bus shelter.
I see.
So we're 10 feet off of that.
So.
Oh, that's smart.
So I will also add, I do think, and I had this conversation with Attorney Nuff, that there are going to be some uses that we're going to have to either address as we see them come into the office or kind of understand as maybe being different than I think retail, restaurant, that we want to see as close to, a street facing property line as we can get it. Daycare uses are unique and different use that have state statutory requirements or state regulatory requirements for play areas, for secure access areas, for individual egress out of classrooms that then requires additional security. So my recommendation to them is maybe understanding what we know through seeing some of these projects. I do think that if our town engineer wants a wider than 24-foot wide driveway for traffic safety purposes, that our town engineer with that level of professional experience should be able to alter that standard, which is an ideal, but not always appropriate in every circumstance. So I just wanted to provide this as an example to say, where possible, where we can think through a couple of these different things, because you all live in town, you go to different projects, you have experience with different sites, there may be a situation where, you know, again, their initial presentation for this showed a left-hand turn lane and an exclusive right-hand turn lane. Now, maybe their traffic engineer, as they look at this, will say, well, based on the volume of cars that we expect within the light cycle, you'll be fine to just have one lane. But that won't always be the case, depending on the size of the development. And so I think it's appropriate to give our town engineer the ability to be able to make an improvement to the site instead of have a black and white requirement. So that's just kind of thinking through that. The other thing that I will say in terms of the comments that we've received from some architects is they want a little bit more flexibility on that first floor. And so, you know, if we choose to put it in here, and so what I've passed out to you is just some of the things where we're starting to see tension for applications that are pending before us. And keep in mind, when I meet with an applicant, I may meet with them 8 months and then not know whether or not they're going to come back. I think that was the case with Attorney Nuff, where we had met a long time ago, and then I wasn't sure whether that client went away, whether they were working out the negotiation of still for the property. It takes there's a long ramp up for development projects. We had another development project, and it's in the project folder, where we have an existing property owner who wants to add a second floor with 3 residential units up above. It's an existing building, but they're adding more than 50% because they're matching that existing property, and they're doing a couple of additions in the front. And so now it would have to adhere to our requirements, and it would also have to adhere to that front setback. So if we could, I think the site plan, if you go to the site plan. So this is an existing 1-story commercial building now. There's a couple of grade changes. They're having to do the same thing as I think this applicant did. And I just want to make sure if they're able to kind of extend a porch that gets closer to that property line, that that's an acceptable solution to be able to add that point of interest, that engagement for the pedestrian who's on the sidewalk, to be able to do that. This is an existing property where there's a side parking lot and a second frontage, just like this application, right? Would we, you know, what would we welcome in that circumstance? Because it's an existing building, they can't move that building closer to the one street. Do we add in language that says for a second, you only have to meet that standard on the primary, most pedestrian oriented, you know, however you want to word it, but it's just something that we need to think through as a commission, just to understand that we're going to be dealing with a transitional period where people are going to want to sometimes have unique uses, sometimes work with some existing fabric of existing buildings, and they may need some design flexibility. So I wanted to provide some physical examples, and I thank these folks for waiting and for being part of this conversation with you as the commission, to just kind of figure out how do we advance the best regulations that we can with those type of parameters.
Thank you. Thank you. By the way, Emily knows where to find me. As I said, I've done this in lots of different towns. If you guys have questions, I'd be happy just to come and chat. So, you know, use me or John or Brandon as a resource if you'd like
I have
to.
a question in light of your experience. I mean, in terms of, what you need is some discretion. And should that be on the staff level, commission level, or should the regulations allow for variation or discretion?
Mackenzie keeps on trickling to the back of my mind. So you can't vary your regulations, but you can do something. So
Make them more liberal.
yes, and I'm also, you know, aware that not every project is unopposed. So I have to think about if there is something in the regulations that someone who opposes us may try to claim that we don't comply with. So anyway, I think what we'll be doing is Emily gave us a really great start with how we can address these things. I'm going to take a really close look at that. We are going to come as close as we possibly can to adhering not only to your current regulations, well, we're going to comply with your current regulations. No question there. We will comply. Or as we may revise them ourselves with, you know, with your approval, but then also comply as best as we possibly can with the architectural regs that probably won't be in place by the time we apply. But we want to, you know, as I said, comply with the spirit. Listen, everywhere you go, it's just like, oh, that's a gateway to wherever. I truly believe this is a gateway from Westport into Southport. Deserves a really special building. I know that the property owner, also former commission member, has always wanted this to be a really special building. This one is, I think it satisfies everyone's desire for something really, really beautiful and charming, and that sort of sets the stage for entering Southport. So anyway, we really appreciate the time.
But I don't know if anything you submitted is has it been formally submitted, like you sort of a list of things that don't work out for you with the design standards that we might be passing? Would it be possible to list those so it's easier for us to tabulate them?
Yeah.
Because you
I
haven't
mean,
formally
I
applied
mean,
yet, but yeah.
We have not weeded through every provision in the
Okay.
architectural regs, but I mean, I identified the ones that were initially a concern and that we are overcoming. So.
Yeah.
Frankly,
Okay, thanks.
Thank you.
Okay, so we will
Did you wanna?
go, Andre, yeah.
Thank you.
I would like to make a request, Chairman. Hi, everyone. My name is Mark Andre. I'm a local architect. I'm not going to comment about all the other stuff, but we've been debating parking mitigation. I think we also should look at to reduce parkings.
We should do what?
Parking production.
Reduction.
Yeah.
I mean, adding more spaces.
Adding more spaces or within the existing that we have. And I have one simple recommendation, right? We know parkings are very expensive. Obviously, I also own properties in town. I work for a lot of folks in town. We get it, right? One section I would like you guys to consider, maybe next time when we debate the architectural standard, is section 28.4 that relates to parking spaces and the diagram in appendix A. Currently, our town only have pretty much one or two sizes for parking spaces, 9 by 18. And what I think we can also look into is compact spaces. Compact spaces are, common in some other town. I think Westport has some. And you can cap it to a certain percentage. So for example, compact spaces, you could look into between 7.5 to 8 feet by 15 or 18 or 16. And that could also allow you to increase some of your parking count in some areas. The architectural standard, I did send my comment. We don't have time. So at the next meeting, I'm certainly gonna be here, and my comment's a little bit more technical, and I'll be happy to share my thoughts.
Great, thank you.
Great, thank you, and I appreciate all of you, everything that you guys doing for our town. Have a good night.
So we'll hold this open, continue it to the next meeting, and that being the last item, we'll adjourn. Thanks, everyone.